matter. B. Chakraborty, Senate counsel for the appellant. What about the cross exhibition?
My lord,
Cross,
I have informed other side, my lord.
what about there is a cross objection?
But I have informed other side. They said that they have no.
No, the cross objection is their petition. Their
My,
appeal.
I understand. My lord. It is again.
Can you have Mr. Kyle?
I told Mr. Kyle. He said, all right.
No, we don't have any problem in
Yes, I also understand, my lord. Right. After some time, my lord, then
after some time. You
some
just
time.
come and make a mistake.
I'll let them know, my lord. Yes.
Just bring.
May I please, Lordship, I would like to pray before Lordship, my lord. I have an unlisted matter, my lord, today, my lord.
Or which day?
Lordship,
When do you want to move?
today at 2 p.m. Lord. Since my construction has been stopped, my lord, during the pendency of the civil suit, my lord. Now again, this same plaintiff approached the municipal board and they are now issuing the stay, my lord. Since the same issue already been pending before the civil court, how can they?
What is the urgency?
My lord, my whole construction has been stopped, my lord.
Why is this
Why-
required to be taken up today itself? Construction is stopped, we'll have it there for tomorrow.
Can we tomorrow, my lord? Otherwise, my lord, I'm facing huge.
What is the urgency that
Well,
if you not
that,
take it on
This construction has been stopped, my lord, because of.
So if it waits for 2 days, it cannot wait for 2 days.
Okay.
Yeah, it's not that urgent. Friday. Have you filed or not?
Already filed on 14th, my lord. Can you
Okay, tomorrow.
tomorrow?
May it please your lordship. Item number 14, 1-4, my lord.
Yes.
I have the consent of the other side.
Hmm.
May I pray the matter be listed after 4 weeks? Technically, matter awaited long back, but we came to know couple of, during the course of the proceedings, we sent the letter. Since the poor people may not know response is coming, I would pray for a last chance after 4 weeks. We have,
2009 matter.
no, it's not that, my lord. The person had died. We did not know an appellant. And we came to know from the other side. I sent a letter. I got back the ID card. You know, some rights would get, that's what I'm praying. Otherwise not.
2009 matter, sorry. 33. 2009 and 23.
It's only on the abatement part, not on the hearing.
It will be abated. You have done
Very
your
good.
duty, sent a
Very,
letter.
very good.
They have not responded, it will be abated.
Very good.
You can come up later for abatement, setting aside abatement. Since they have not responded,
That's what.
we record your submission.
No, lordship. Obliged.
May I please? Item 30, your lordship,
30.
30.
Yes.
The IA was filed under order 1 rule 10, your lordship.
Hmm.
So that this petition may be considered at the time of final hearing of RFA, your lordship. Because full length hearing is necessary in this case. Whether the, yes,
I will consider.
yes, your lordship, at the time of hearing,
Why?
it may be considered. Because it needs some length of hearing, your lordship.
Doesn't matter. We'll dispose of the IA. What is the difficulty?
With the consent of the others, then that has to be passed over for today, your lord.
We'll pass it over Friday.
Yes.
Sri NN Upadhyay letter counsel. Praise for some accommodation. Full stop. Please. On Friday. Friday is a holiday. Monday.
Monday,
Monday next.
lovely. Or Tuesday if it is
Monday.
May please, your lordship, actually for listing a writ petition, we have filed it on.
Writ petition
Writ petition.
in this court.
Other court is not sitting today.
Bench one. This is bench one. You have to move the honorable chief justice among decisions.
This is civil bench 4 matter, madam.
Civil bench four. There will be another court taking up the civil bench four. This is civil one. Only civil matters. Not writ petition. Okay, next.
May please, Your Honor, I'll take to mention item number 2, my lord, somehow I missed the case, my lord. Petitioner counsel is there, my lord, maybe fixed on another date, my lord.
Somebody is appearing in person.
In person, my
He was
lord.
appearing earlier, later on I have been engaged.
Okay. Yes, when?
25th, my lord, started.
On minute, 22nd, minute, 22nd or
22nd, I
24th.
have some difficulty.
24th.
24th, my lord, yes.
A prayer for adjournment has been made by MSA Gayan Learned CGC. Put up 3S Kahur Learned Council for the petitioner is present, full stop, as agreed to by the parties based on 24th August. Is there any interim order?
Actually, may please, my lord. I beg to mention for listing up a CRP, that is 14/14 for withdrawal, my lord.
Okay,
It is listed in the regular hearing cause list as item number 36, my lord.
we can have it. 36. Part 2 আছে। Part 2 reference গুলো আছে, হ্যাঁ? এই উপর part 2 জানা। Oh. It's not there in the court record. You, we may allow it. Monday you bring.
Monday,
Because day after tomorrow is a holiday. I think.
holiday.
Can you bring it tomorrow?
Yes, my lord. You can.
Withdrawal.
Withdraw. Highly obliged.
May I please, your lordship? Lordship, I beg to mention item number 12, lordship.
12 years.
Lordship, may kindly adjourn the matter for the day, lordship.
It did matter. Other side has not appeared.
Lordship, it has come for the first time, lordship. Before, earlier there was a delay continuation petition, lordship, that was allowed.
Okay. On the prayer of MSF Ahmed Learned Council for the appellate list,
Lordship, next week,
list next week.
deeply.
May I please your lordship, with the consent of the other side, I beg to mention item number 33, 34, 35.
33, 34, 35 years.
Lordship may kindly adjourn for 2 weeks, lordship. 30
33 is a review petition.
review.
Here for whom?
Lordship, I am for respondent number 1.
For the claimant.
Yes, lordship.
The other side has been informed.
I have already informed
Yes,
lordship.
21.
Lordship, 30, if possible, 38
30th of August.
August. Obliged.
On a request made on behalf of the respondent number 1 claimant. Comma. Matter is adjourned to be listed on 38. Please tell.
Obliged.
May it please, your lordship? I beg to mention for listing of an IA to come up for orders.
I for
IA is for restoration petition, my lord. Our appeal
it
has
has been
been.
dismissed for default. Monday.
Must
May I please, your honor? Lordship, I beg to mention item number 40 and 44, lordship.
Hmm.
With the consent of the other party, kindly adjourn the matter for the day, lordship.
40 and 44.
44, lordship.
You are with Mr. Goswami.
I am for appellant lordship, Mr. S.K. Goswami.
A prayer has been made, a prayer for adjournment has been made on behalf of Sri S.K. Goswami Learned Council for the appellant. List after a week. 40 and 44.
Lordship,
40, 44.
obliged, lordship.
Yes,
May I please, lordship? Lordship, I beg to mention item number 13, lordship.
1-3.
Yes, lordship.
Yes.
Due to some personal difficulty of my senior, matter may be adjourned for today, lordship. Next day.
MSB Talukdar Learned Council submit that our senior Sri K. Bhattacharjee
Yes,
is
lordship.
having some inconvenience today and ask and therefore prays for an adjournment. So, list after a week.
Yes. Much obliged.
Wait, please, madam. Well, listing of the RSA in the next week, madam, for admission under order 41,
A fresh matter.
freshman. Deeply.
May I please, your lordship? Lordship, I beg to mention for listing of an in-test case for orders, lordship. Any date next week.
What is the stage?
Lordship, it was without admitting the case, lordship. It was put for hearing, lordship.
It has to be admitted.
Lordship,
Come up for admission then.
lordship,
The next week, give a date the next week.
lordship, obliged, lordship.
May it please, your lordship. Lordship, one RSA of 2014, lordship. They are now, lordship, they have started construction. So we have filed one injunction on 14, lordship. My junior mentioned your lordship has granted date on 23rd. Can it be on tomorrow, lordship, if your lordship permits? They have already started construction, lordship. I have annexed some photographs also.
When have we given? 23rd.
Yes, lordship.
tomorrow will be difficult. Make it on 21st.
Lordship.
Where is the memo? Somebody
No,
has given a
Lordship,
memo.
I will file the fresh memo, Lordship. Obliged.
When was the mention made? Today itself.
No, Lordship, on 14th itself, Lordship. 14 itself, she made, Lordship.
Then difficult then. If it's gone as the order of this court, it will be difficult.
No, Lordship, I'll contact the section and inform that a fresh mention memo has been made today,
Let us see, but
Lordship.
you should be consistent with your prayers. Difficult to change orders like this. Try it if
Lordship, obliged.
and by one day, what difference will it make? 21st to 23rd.
21st, 23rd.
What difference?
And it's Lordship, Lordship. Let it remain on.
But ensure on 23rd it comes.
Mid-page, Lordship. Lordship already heard this matter in part 2 list, Lordship. The appellants are the defendants. And Lordship, the substantial question of law that I raises is that suit of the plaintiff is barred by limitation, Lordship. Florida pages.
You have to argue again. I think we have heard long time back.
Yes, Lordship.
There are two
Lordship may
questions.
forget.
Two
Yes,
questions.
two
You had
questions.
planned.
One regarding order 6, rule 4 fraud, Lordship. And
Some
another,
mutation in collusion. That was your allegation.
yes, Lordship.
But you have to narrate.
Plaintiffs, Lordship,
We'll finally hear and dispose this.
Yes, Lord.
2002.
That's right.
But is there anything?
My lord, yes, only one issue, lordship, the last
No, we
one is
don't remember. We have to hear you.
not.
But is there anything to be decided actually?
yes, Lordship, their suit
Now,
is barred by limitation.
Will you
that I
get
will-
anything?
That I will show you,
That-
Lordship.
Now, will you actually practically get anything? Suppose we allow this appeal.
Lordship,
Will you get anything?
that Lordship, the clients will know. I
My
have
lord,
no-
there is no prayer for record, I mean, my prayer is for
For
confirmation.
confirmation, and we are saying we are
Yeah, I am in possession all throughout. So
in. Lordship.
for 100 years for my since my previous.
See,
At
both
least-
of you
There is
are,
there is no counterclaim. But if there is counterclaim for recovery of possession, the matter would be different.
no, there is no, we remember, there is no, you are seeking confirmation of possession.
That's right.
They are also saying that they are in.
We are in possession, Lordship.
You remain in position, both of you.
Lordship.
Be happy.
Our first question was, Lordship, whether the suit praying for
No, you have to
cancellation.
tell us the fact. We-
Lordship. The plaintiff's prayer is that, Lordship,
Just a minute, just. Start from the scratch, Mr. Chaudhary, we have forgotten everything. Appellant is the,
defendants, Lordship.
how many appellants?
Lordship, there are 1, 2, 3, 3 appellants, and in the meantime, one died. And they were substituted. And 3 also, 4 appellants, Lordship, earlier, then 1 and 3 died, Lordship.
Four appellants. 1 and 3 died,
Yes, Lordship,
substituted.
they were substituted, Lordship.
Okay. Yes,
Title suit judgment, Lordship.
now what was the suit was for what?
Suit was for cancellation of the recording of the name of the defendants from the revenue records, Lordship.
Suit,
Suit, Lordship.
suit for cancellation of mutation.
I'll read the prayer portion, Lordship. Page 87, Lordship.
Hmm.
It is therefore prayed that a decree be passed declaring the plaintiffs have got right title and possession in respect of the,
Suit for declaration
yes, Lordship, described in
of
the
right title interest.
Schedule A of the plaint.
Yes,
Defendants be restrained by an order of injunction not to trespass into or encroach upon the plaint
injunction
schedule land.
for restraining,
Yes, Lordship.
restraining
Plaintiff schedule land and or restrict the possession of the suit or to Lordship, it cannot be understood. Strict the possession of the suit land. Then confirmation of possession, page 88, and then cancellation of the names of the defendants from the records of rights maintained by Revenue Department, wherein the names of principal defendants appears and liable to be struck off and deleted. Any other further relief or relief. So along with right title interest, cancellation of name of the defendants from revenue records also.
yes. You contested.
Yes, Lordship.
How many of you are there?
Defend 1 to 4, Lordship.
What if they are all there or
1 to 4 file written statement, Lordship.
four defendants?
Yes.
Yes, there.
So as the point was for suit is barred by limitation,
You are
Lordship.
taking the point.
Yes, Lordship. Written statement, I have taken the point that the suit is not maintainable in para 2 and in para 3, the suit is clearly barred by limitation. And plaintiffs, Lordship, their pleadings, I'll show from their pleadings that the suit is barred by limitation, Lordship. Para 6, Lordship, page 81.
Of your WS.
No, of the plaintiff, Lordship.
'81.
Para 6, page 81, last paragraph. That Idris Mia, Abdul Karim, Abdul Rahman, and Kasim Ali, by a registered deed of reconveyance, got the land returned from one Badaruddin, son of Hilaluddin, including the land of CS Patta number 97 of Dag number 688. Para 7, that the defendant's predecessor in interest, Sikandar Ali, Bakhte Jaman, Kamrud Jaman, son of Gabru Mia, collusively got their names mutated in CS Patta number 97, Dag number 688, allegedly by right of purchase in the year 1912 and 1913. That objections were raised promptly against the false mutation for which it was cancelled, which is evident from the fact that their names did not appear in RS Patta number 137, save and except the name of Sikandar Ali. So, Lordship, from this pleadings could be understood that, Lordship, they promptly raised objections. So it was within their knowledge that, even for argument's sake, I admit that our names were wrongly recorded, Lordship. So it is within their knowledge, so they promptly objected, and their contention is that immediately our names were deleted, Lordship, except Sikandar Ali's name remained, Lordship. Sikandar Ali died leaving behind his daughter Musammad Meher Banu Bibi who was married to Umar Ali of Singarbon. She died leaving heirs who are impleaded as defendant number 6A and 6B. But from the revenue records, it appears that instead of mutation of the name of
Can
the
you,
sum
can
of
you narrate the story in brief?
lordship,
Who are you? What is the land? It'll be easier for us.
the real facts I will go
Yes,
lordship.
yes.
Lordship.
First, give us the facts which as per how you project this activity.
Page 98, lordship,
You tell us who are you?
that the real facts in
No,
addition
no, you
to
tell
the
us, tell us. Don't read, tell us.
lordship. Our case is that lordship. There are so many darks and patta numbers, lordship. May I
Give us in brief,
read out, lordship?
we'll just have an idea. What are the facts?
Lordship. Our case is that one Idris Ali and Hauni Bibi were owners of entire land of CS Patta number 97 in equal shares. They sold away the entire land.
CS
as a-
Patta,
Lordship,
97.
97.
Who
in
are the,
equal-
who are the original owners? Idris and
Idris Ali and Hauni Bibi.
joint owners.
Yes, Lordship. They sold away the entire land measuring 5 katha, 7 chataks of Dag number 688 in
Oh.
CS Patta number
One
97.
They sold how much land? Five
They sold
katha,
the entire land measuring 5 katha, 7 chatak.
entire land.
Yes, Lordship, of Dag number 688.
5 katha, 7 chatak. Under Dag number
688, Lordship, in CS Patta number 97.
Hmm.
To Sikandar Ali, Bakhte Jaman and Kamrud Jaman, the persons whose name were recorded in the revenue records, Lordship.
Sikandar Ali,
Bakhte Jaman
and
Kamrud Jaman, son of Gabru Mia.
all three
Yes, Lordship.
sons of
Son of Gabru Mia.
Gabru.
Yes, Lord. Gabru. And their
When was
name,
this transaction?
that was not written here, Lordship.
Then
And their names were mutated in the Jamabandi of Suit CS Patta number 97, and they became co-sharers of Said Patta,
these three, Sikandar, Bakhta and
Sikandar Bakhte and Kamrud Jaman.
okay, their names mutated. Names mutated.
Yes, Lordship. Regarding that mutation, Lordship, objection was raised by the plaintiffs, Lordship. Names were mutated in the year 1912 and 13, Lordship, by a mutation case number, Lordship.
Okay. And this mutation was objected by the plaintiff.
Plaintiffs, Lordship. Their prayer was for deletion of that mutation, Lordship, recording of name of the defendants. So I am saying that this prayer was barred by limitation, Lordship. 1912-13.
Okay, thereafter,
The
you
said-
say that if these names were mutated in the year 12-13,
13 on
in
the
the
basis
present
of a-
suit, they could not have raised this issue because they were aware at that time itself. And it is
They
apparent,
said- they
and it is
said-
apparent that since they have raised objection, that
Lordship,
means they cannot now say that they were not aware of it.
Lordship,
So limitation will start from that point of time.
Lordship. And their case is that, Lordship, as they objected, our names were deleted and then only Sikandar Ali's name remained. But my case is that they
One second,
could not prove, Lordship.
Objection were accepted. Mutation cancelled. Only Sikandar Ali's name was there.
Yes, Lordship.
Sikandar. Retained. Okay. The plaintiffs are the descendants of Sikandar.
No, Lordship. They are the descendants of.
Okay, then you go on.
Can we create also?
You carry on, you carry on.
Lordship. So my contention is that, Lordship, when from the plaint itself, there is no pleading that from this date cause of action arises, Lordship. One sentence is there: after the death of Kasim Ali, they started disturbing in
Who is
the
Kasim Ali?
Kasim Ali, their predecessor, Lordship. It is in the plaint stated by the plaintiffs. In para 8A, they have mentioned that after the death of Kasim Ali, his heirs, that is his sons, Abdul Aziz and Abdul Hai's names ought to have been mutated, but instead the names of his brothers together with Sikandar Ali, son of late Gabru Mia, was mutated most illegally. Sikandar Ali's name cannot be mutated upon by any stretch of investigation which is apparently
Imagination.
fraudulent. So there
Any
is
stretch of imagination, not
Lordship,
investigation.
stretch of investigation or
It should be imagination.
which is apparently fraudulent. So
But
there
what is their source of right over this land?
their source of a deed of reconvenience, Lordship.
By whom?
That Idris Mia, Abdul Karim, Abdul Rahman, and Kasim Ali by a registered deed of reconvenience got the land returned from one Badruddin, son of Hilaluddin, including the land of CS Patta number 97 of Dag number 688.
And they are sons and daughters of Idris Ali.
Lordship.
How is he connected to Idris Ali? You say your case projection is that Idris and Honi were the original owners. Correct.
Sabu Mia and Gabru Mia are two brothers, Lordship. Plaintiffs are from the Sabu Mia, legal heirs of Sabu Mia, Lordship. They are descendants of Sabu Mia and we are the descendants of Gabru Mia, Lordship.
No, but you traced your right to a sale which was done by Idris and Honi.
Yes,
correct?
Lordship. Yes,
Of 5 Katha, 7 Chatak under Dag 688 to 3 of you,
97.
Sikandar, Bakte, and Kamruz.
Yes,
And you 3 are the sons of Gabru,
yes, Lordship.
and they are the sons of Sabu. How are they
Sabu-
connected?
Sabu Mia, Lordship.
Sabu, how are they connected?
One Muhammad Yusuf was there, Lordship. His two sons, Sabu Mia and Gabru Mia.
Yes.
Then Sabu Mia has 4 sons, Idris Ali, Abdul Rahim, Abdul Rahman, Kasim Ali.
Hmm.
And plaintiffs are the descendants from this Kasim Ali. Kasim Ali, 2 son, Abdul Aziz, Abdul Hai. And plaintiff is Abdul Rashid Chaudhary, son of Abdul Aziz. So he is the 5th generation of Sabu Mia, Lordship.
Not
And-
clear.
We are the son of Gabru Mia, Sikandar, Bakhtet Jaman, Kamrud Jaman. So we are from Kamrud Jaman, Lordship. Abdul Mannan, that is defendant, Lordship.
No, that is okay. You trace your right to a sale deed.
Lordship.
How do they trace their right? Their claim is based upon what?
Their claim, Lordship, that is
You have not made a family tree or how
No.
it has evolved.
Lordship. Their case is that, Lordship, by the registered deed of reconveyance, got the land returned from one Badruddin, son of Hilaluddin, including the land of CS Patta number 97 of Dag number 688.
But you said that yes, this land was originally owned by Idris and Honi.
Idris and
Hauni Bibi.
Hauni Bibi, Lordship. We have purchased from Idris and Hauni Bibi.
Now their reconvenience is with whom?
Badruddin, Lordship.
How is Badruddin connected with Idris and Honi Bibi?
Lordship. That they have not stated, but Lordship, in para 3,
Lordship may take the
plaint,
trial court judgment, will not, that is
No, first let us understand. We can go by the judgment.
High Court has not given the details.
How is your, how do you trace your right, Mr. Roy?
By right of reconveyances, by right of reconveyance. Our names are there.
Huh?
But in fact, what happened? There were two brothers, Sabumia and Gabrumia.
One second.
Sabumia and Gabrumia.
They were sons of,
Mohammed Yusuf. They are sons of Mohammed Yusuf, Lordship.
both sons of Yusuf.
Yes, Lordship.
Okay, then what happens?
Sabumia had, my lord, 4 sons and 1 daughter. Idris Mia, Qasim Ali,
Idris, Qasim,
Abdul Rahim and Abdul Rahim.
Abdul,
Abdul and Abdur.
Abdul Rahman.
Abdul Rahim and 1 daughter, Meherjan Bibi. My lord, Idris Mia had 1 son.
97.
Yes.
Idris Mia had 1 son. Talen Mia.
Talen,
Talen, Talen Mia, and 2 daughters.
Hmm.
Asia Bibi and Laila Hazi. Qasim Ali had 2 sons.
Qasim Mia,
Qasim Ali, second son
Oh.
of Sabumia, had 2 sons.
yes,
Abdul Aziz and Abdul Hai.
okay,
Abdul Aziz had 1 son.
yes,
Abdul Rashid Chaudhary is plaintiff number 1.
okay. Okay,
The other son of Qasim Ali, namely the Abdul Hai, had 2 sons.
Hmm.
Abdus Samad Chaudhary,
Faiz Ahmed.
he is plaintiff number 2.
yes,
And Faiz Ahmed Chaudhary, he is plaintiff number 3.
okay.
And this, they purchased, my lord,
Who,
from Ashia Bibi.
who?
This plaintiffs
Okay.
purchased from
Three
Ashia,
plaintiffs,
my lord,
3 numbers of plaintiffs.
3 number of plaintiffs. No? 3
Three
plaintiffs. They purchased from Ashia Bibi.
With this particular plot of land,
Yes, Ashia Bibi. The daughter of
Asya Bibi is the daughter of Qasim. No, Asya Bibi is daughter of Idris.
Idris, lordship, right? Idris.
Okay. By registered deed.
By registered deed.
When was this purchased?
Dated the number, this is the patta number 97, dag number
688.
688.
This is Sukland. No, when was it done? When was the purchase made?
That I'll give you, lordship. Just
Not the date, the year.
Well, I'll just,
If you have the deed number, the year will get after public.
yes, my lord. I'll give you, lordship.
Oh. Then
I'll tell you about Gabrumia. Gabrumia, my lord, line of succession, my lord. Gabrumia had 3 sons.
Gabru had
3 sons.
Gabru had 3
Sons.
sons. Yeah, Sikandar, Bhakti,
Sikandar Ali, Bhakti Zaman,
Zaman and Kamru Zaman.
Kamru Zaman.
Yes.
Now, Sikandar Ali has his wife is Meherban.
One second. Gabru Mia.
Gabru's son Sikandar's
Gabru
wife,
Mia. Let us make clear. Sikandar Ali, then
Sikandar Ali, Bakhtujaman, Kamaruzzaman, 3 sons.
this
And Sikandar's wife is Meherban Bibi.
Amruz. Sikandar's wife.
Is Meherban Bibi.
Then
And my lord, perhaps Bakhtujaman died issueless. Bakhtujaman, I'm not sure, I don't find. Kamruzzaman,
Adopted one Abdul Mannan.
Kamruzzaman had
4 sons. No, three
sons, my lord, for
3 sons, 1
two-
daughter.
2 sons, 2 daughters. No, no. 2 sons and 2 daughters. These are dependent.
Hmm.
Abdul Hakim, defendant number 1.
Hmm.
Then Abdul Hannan.
dependent.
Dependent number 2. And then daughter, defendant number 3. Daughter Lamta, defendant number 3. Abdul Hannan.
Ibetun Bibi. Ibetun Bibi.
Ibetun Bibi is another defendant number 4. Defendant
four.
number 3.
Abdul Hannan.
Abdul Hannan.
Abdul Hanan, you have said,
Oh no, it is Abdul Mannan. Abdul Mannan. Defendant number 2 is Abdul Mannan,
not Hanan.
not Hannan. Mannan.
Okay, Mannan.
And
Dependent 3.
3 is Abdul Hannan.
Hannan.
How can it be Abdul?
Hmm.
Daughter Abdul.
No.
That means 1 daughter.
Huh?
Abdul Hanan is defendant number 3.
3 sons, 1 daughter. Ibetun Bibi.
3 sons.
3 sons.
One
Abdul
daughter.
Hakim, Abdul Hanan, Abdul Mannan.
Yes.
And 1 daughter.
1 daughter.
Name?
Ibetun Bibi.
Defendant number
I-
3 son.
Son.
Oh, okay.
Musammad Ibetun Bibi, defendant number 4. IBETAN. So Kamruzzaman have 4 legal heirs, Lordship.
Yes.
4.
Now it happened like that. Well, my lord friend may continue, or I can.
Just complete this line.
Well, this is complete now.
No, but see, originally there were Sabu and Gabru.
Gabru and Sabru.
You
Yes,
come
Sabru.
from the Sabu line.
My lord,
Yeah.
You come from Sabu.
I come from.
Because Sabu's son is Qasim.
Yes,
Qasim's wife, daughter is Asiya.
yes,
And from Asiya, you said you had purchased.
yes.
Correct? Otherwise, you are the.
No, Idris's daughter is Talen. Yes,
No, Asiya is the daughter of Qasim.
yes.
Sorry. Asiya is daughter of Idris. You're correct.
Idris,
Idris. And from Asiya, you 3 have purchased.
lordship.
And you are otherwise sons of Abdul Aziz and sons of Abdul Hai.
Abdul Aziz
21,
Abdul-
21 is the son of
Abdul Hai,
Aziz,
right? The lordship. is right.
and 24, 2 and 3 are the sons of Abdul Hai.
Yes.
And both your fathers were the sons of
Qasim Ali.
Qasim Ali.
His father is Subu. Subu me alignment.
No, your line from Qasim to Subu is not very
Yes,
important.
yes.
What is important is
Qasim,
you claim to have purchased from Asiya Bibi, who
lordship,
is the daughter of Idris.
lordship.
That means we have to trace the maybe your the right of Asiya Bibi from Idris.
Lord.
So if Lordship Idris already sold out to the dependents, how the daughter will retain that share, Lord?
And you are saying that Idris has sold to you.
Yes, Lordship. Hauni Bibi is
No,
the daughter.
no document. True.
Idris and Hauni. You purchased from Idris and Hauni.
Hauni.
How is Hauni connected with this man?
Hauni is the daughter-in-law of Idris, Lordship. His son died. So lordship,
who's-
she is
who-
the widow of his son, lordship. Pawnee Bibi and lordship,
Idris had one son, Talan Mia.
lordship will find that in para
No, no,
three,
Idris had one son, Talan Mia.
the
Pawnee is
Pawnee is the wife of
wife of
Talan.
Talan.
Yes, that is admitted by the plaintiffs in para three, lordship. Para three, last two lines, lordship, that CS Patta number 97 was issued in favor of Idris Mia, son of Sabu Mia, and Musammad Hauni Bibi, wife of late Talan Mia. After that paragraph, lordship, in para 4, last line, they have stated that plaintiffs purchased their share by registered sale deed. So there is no other lordship information in regard to their sale, lordship. But we have.
Is a sold it from whom?
They are saying lordship from the daughter of Idris Mia. If we have already purchased the share of the entire land of Dag number 688 from Idris Mia and Hauni Bibi, then what remains to sold by the daughter of Idris Mia, lordship?
And you also claim that by this, on the strength of your purchase, you are in possession.
Yes, lordship,
And they say that by their strength of their purchase, they are in
lordship. And our names were recorded in the year 1912, 1913.
13.
They objected in their case that Sikandar Ali's name remained and other names were lordship deleted. And later on, again, we have incorporated our names, lordship. So maybe by wrong lordship, the name of other lordship recorded Patadars names were deleted and later on that was rectified, lordship. All those exhibits were exhibited by the plaintiffs, lordship. The Jamabandi and sale lead Jamabandi, they have already exhibited, lordship. Exhibit 3 is the certified copy of CS Patta number 97, lordship.
Now the suit was decreed in their favor. Suit was decreed in their favor.
Your lord.
Yes, lordship,
And first appellate court affirmed.
lordship. The first appellate court also says, lordship, from date of knowledge, suit is within time. Lordship, there is no pleading in the entire plaint when their date of knowledge started.
This appeal has been structured only on the ground of limitation.
Limitation and another, lordship, their allegation is that we had committed fraudulent, lordship, activity while recording our name. So I am, lordship, arguing order 6, rule 4 of CPC, lordship, for fraudulent pleadings, lordship, is to be specific. Merely saying that by fraudulent, we have entered our name in the revenue record is not, lordship.
Let us see what are the substantial questions. I think 11/3/2003. Order.
11/3/2003, lordship.
Yes.
Heard Mr. B.K. Acharjee, learned counsel for the appellant, admit the appeal, call for the records issued and said the second appeal would be heard on the following substantial questions of law, whether the suit praying for cancellation of the mutation of the appellant's defendant is barred by limitation. Whether the learned court below erred in inferring fraud in the mutation record exhibit 1 in the absence of full particulars thereof as required under order 6, rule 4 CPC and without any proof thereof. So merely saying that there is fraudulently we have entered our name in the revenue record is not sufficient, lordship. That too, lordship, after,
Order 6, rule 4.
yes, lordship. Yes. Particulars to be given where necessary, lordship.
What is what they have failed in their the details of this.
Lordship, they
Public-
failed to discharge their burden saying the full particulars of fraudulent activities. They have merely one word fraudulent, Lordship. In para 4 most probably, Lordship. In this regard, Lordship, I want to cite some decisions of Supreme Court and as well as from our High Court also, Lordship.
What is the decree? Let us read the decree for trial court judgment first. Where?
Lordship, trial court judgment is page 26. May I take your Lordship to the issues, Lordship? Page 38 is the issue, Lordship. Issue number 2 is the suit barred by limitation.
Page
Page 38. Having perusal of the pleadings of the respective parties and hearing them on the same following issues were settled for just determination and
yes.
decision of the suit. Is there any cause of action?
So we have read this.
Lordship,
Number 2 is barred by limitation.
yes, Lordship.
Then where is the discussion?
And issue number 5, Lordship, had the defendants and their predecessors illegally and collusively got their names mutated in the record of rights of the suit partner. These two will sufficient, Lordship.
Yes.
Issue number 2, page 57, Lordship.
Yes.
The defendants in para 3 of their written statement allege that the suit is barred by law of limitation. The learned counsel for the defendant in support of the above averments contended that in the instant suit, the prime object of the plaintiff is to get cancellation of the mutation of the predecessor in interest of defendant, namely Sikandar Ali, Bakhte-Zaman and Kamruz-Zaman, which was recorded in the year of 1913, that is more than 80 years back. The limitation for such cancellation is 3 years from the date of right to sue. He contended that the defendants Abdul Hakim, Abdul Mannan, Abdul Hannan and Ibetun Bibi also got their names recorded in the suit patta about 17 years back, and the plaintiffs did not raise any objection against the said mutation within the said period and remain asleep till the year 1996. So according to the learned counsel, the suit is absolutely barred by law of limitation. The learned advocate referred the evidence of PW1 recorded in page number 17 and 18, where he admitted that the mutation of the predecessors was done more than 50 years back, but the case seeking cancellation of mutation has been filed, causing more than 50 years delay. In reply to the point of barred by limitation, the learned counsel for the plaintiff submitted that the suit is not barred by law of limitation. The learned counsel for the plaintiff argued though the mutation of Sikandar Ali, Bakhte-Zaman and Kamruz-Zaman was recorded in the record of rights in the year 1913, and then Bakhte-Zaman, Kamruz-Zaman again in the year 1919, but they never staked their claim over the possession of the schedule mentioned land and plaintiffs remain all along in continuous possession over the suit land. He contended that the plaintiffs were not aware of the fact of defendants and their predecessor in interest illegally or collusively got their names recorded in the suit patta in respect of the land described in Schedule B. They only came to learn about such illegality in the year 1994, but it is not mentioned in the plaintiff version. While the principal defendants take their claim over the Schedule B land in the guise of false and collusive mutation of the predecessor in interest in the year 1994 and threaten the plaintiffs to dispossess from the Schedule B described land, the learned advocate for the plaintiff explained that on the staking claim of the Schedule B described land by the principal defendants, the plaintiffs made inquiry into the claim of the defendants and ascertained the fact of collusive mutation of the predecessor in interest of the defendants on 17/12/94, and these are the dates, and finally on 3/5/96. By obtaining certified copies of relevant documents. Upon perusal of the certified copies of Jamabandis of second RS Patta number 215, RS Patta number 137, CS Patta number 96 and 97 marked Exhibit 1 to Exhibit 4, as well as certified copies of mutation order dated 27/8/13 marked as Exhibit 12, it can be presumed that the plaintiffs finally came to learn about the collusive, false and illegal mutation was done in respect of recording the names of the predecessors in interest of the defendants, and thereafter the names of the defendants in the record of rights of the suit land only on 3/5/96 after obtaining the certified copy of the application of the mutation application and the order. As per Article 59 of Limitation Act, the period for 3 years to cancel or set aside an instrument or decree started from the date of knowledge about the fact of instrument or decree sought to be cancelled. It is revealed from the certified copy of order dated 29/8/13 marked as Exhibit 12, as well as from the evidence on record that the plaintiffs came to know about the false and collusive mutation of the names of Sikandar Ali Bakhtir Zaman and Kamrud Zaman, and then the mutation in the names of defendants first only in the year of 1994 and 1995. Though the exhibits were exhibited, Lordship, no official witness were called to prove those documents, Lordship. Only PW plaintiff Abdul Rashid reduced evidence, Lordship. One PW only, Lordship. While the defendants threatened them to dispossess out of the
No,
possession.
this, your submission, are you disputing that your names are not in the Jamabandi?
No, my
That
names,
fact is not
no,
disputed.
their
So-
case is that, Lordship,
so
our names,
here the case of adducing evidence to the official may not come because the fact as such is not disputed.
Lordship. But
You
they
are
have-
saying that merely by a certified copy obtaining in the year 1994-95 may not mean that they have acquired the right only in 94-95.
Lordship.
That is
And
your,
one more thing, Lordship, their allegation is that, Lordship, our names were deleted. So they proved that our names were deleted. So they cannot say that they proved that our names were deleted until and unless they call the revenue officials to prove that fact, Lordship.
but did your name appear?
No, Lordship,
In the
our
meantime-
names were there, Lordship. 1919, we again, our names were there, Lordship. In the revenue records, Lordship.
No, they say that immediately on coming to know initially, 12-13, they
Lordship,
had objected.
Lordship.
Some rectification measures were taken,
Our names were there,
Cancel.
Lordship.
Cancel.
cancelled.
Cancel, Lordship. There,
Then again fraudulently entered.
no, Lordship. That is the why entered, Lordship, merely saying that fraudulently entered, Lordship, without calling any
No, are you
official, Lordship.
disputing the cancellation in 12-13?
No, cancellation, Lordship, may be due to some mistake.
No,
made, Lordship.
are you disputing?
We have not we exhibited any document for Jamabandi, Lordship. We are only rent receipt we have exhibited.
No, are you disputing that their averment that in 1912, 1913, when the names of your predecessors
Lordship.
were found in the rights of records and they had objected, it was cancelled.
No, I'm not disputing lordship, but lordship, they have exhibited some documents.
If
some
you're not
registered-
disputing, your explanation that it might have been cancelled due to some other reason, that
Lordship.
would be a very weak kind of an explanation.
That will help lordship only Jamabandi and all these documents, but their registered dates will prove lordship, only PW1, only one witness lordship. So their purchase deed, they have not proved lordship, on the basis of which lordship their right title was declared. Lordship. And we are the defendants. Lordship.
If there was an additional prayer for recovery of possession, then
Lordship.
the question of title would have attained much significance.
Lordship.
Now they are praying for confirmation of possession on the
Lordship.
strength of a registered deed.
Lordship.
And they have also said that your names have been mutated collusively and they want cancellation. And
For
on
collusive,
the strength of your mutation, you had tried to force and turn to land, therefore this was.
Lordship.
Under those circumstances,
For lordship, saying that collusively we recorded our names.
in
they
your
ought
written
to have
statement, did you contest their right, their title over the land?
That lordship, I have to check.
Was there a
Whether
specific pleading?
specific denial is there, the suit is barred under the specific relief act under the mention of some land. And lordship, the PW1 also admitted that on that person, he instituted the suit. Two persons' name were incorporated as defendants, that those persons are dead at the time of filing
That is
suit.
okay, that
lordship.
is okay.
That is another aspect is there, lordship, he admitted.
Now we have to
And
proceed, we have to
PW
proceed.
On the point of
Proceed
limitation
only
also,
on the, by taking into consideration what is the nature of the suit.
lordship. On the point of limitation, lordship, PW1 already admitted in his evidence that the revenue records were corrected in the before 50 years ago, lordship. So he filed the suit after almost 50 years.
Where is the finding of the trial court or the appellate court that in 1213, when the objections were raised, the mutation, your names were cancelled?
In my plate, it is there. I have pleaded.
Title suit judgment, lordship.
In the judgment,
May I read issue number 5, lordship?
yes,
Trial court, page 53, lordship.
53.
53, lordship.
Issue 5.
The plaintiffs in their plaint allege that the predecessor of principal defendants Kamrud Jaman and his two brothers, namely Bakhte Jaman and Sikandar Ali, collusively got their names mutated in the record of right of CS Patta number so in respect of entire Dag land of Dag number 688, showing to have been purchased from Idris Mia and Hauni Bibi. According to learned advocate for the plaintiff, neither Idris Mia nor Hauni Bibi during their lifetime sold any land of Dag number 688 of CS Patta number 97 in favor of Sikandar Ali, Bakhte Jaman and Kamrud Jaman. His contention is supported by the defendant number 1, who disclosed in his cross-examination that there is no any documents in their possession showing the fact of land containing Dag number 688 of CS Patta number 97 sold by Hauni Bibi to Sikandar Ali, Kamrud Jaman and Bakhte Jaman. Exhibit 3, certified copy of CS Patta number 97 shows that Sikandar Ali, Bakhte Jaman and Kamrud Jaman, son of Gabru Mia, got their names mutated on the strength of order dated 27/8/1913, passed in connection with mutation case number 1807, 1912 and 13, showing the entire land under Dag number 68 purchased from Idris Mia and Hauni Bibi, but the defendant number 1, while deposing as DW1, has stated that Sikandar Ali, Bakhte Jaman and Kamrud Jaman purchased the land under CS Dag number 688 from Hauni Bibi. The evidence of DW1 found contradictory to the contents of entry in CSM. So in entry, it is reflected that registered deed in the name of two persons from purchase from two persons, and DW1 orally stated we purchased from Hauni Bibi, lordship. As regards purchase of land under Dag number 688, Dag number 688, Exhibit 12, certified copy of application filed by Sikandar Ali, Bakhtiyazaman and Kamruzzaman seeking mutation of their names in CS Patta number 97 in respect of land contained in Dag number 688 measuring 8 Katha 7 Chataks claiming to have been purchased from Pattadar Idris Mia and Hauni Bibi. Report of Lot Mandal submitted in the said case shows that on field verification, he found that the applicants have been possessing the land since 8 Jyeshtha of 1316 Banglasan. On being purchased under a registered deed from Idris Mia and Hauni Bibi. So the report does not indicate the deed number. There is no indication about service of any notice to the Pattadars and hearing them in the order of mutation. This clearly shows that mutation order passed behind the back of the knowledge of Pattadar Idris Mia and Hauni Bibi. The applications for mutation shown to have been filed on 27/6/13, where Lot Mandal submitted his report 23/8/90. It ought to be 13. version. And the mutation order was passed on 29/8/13. This almost also smell that the applicant Sikandar Ali, Bakhtiyazaman, Kamruzzaman got their names mutated in respect of land under Dag number 688 collusively with the staff.
In 6 days. In 6 days it was
Lordship.
mutated. 23, you had filed
27, 27/6/13.
No,
then-
on 23rd you have filed, and 29 it was mutated.
No, Lordship, report is after 2 months, Lordship, 6, 7, 8, after 2 months.
Oh, after the report, okay, report
Yes.
was on 23.
Yes, Lordship. After obtaining a report, Lordship, records were corrected.
Then,
The plaintiff stated that immediately after getting information about the fact of Bakhtiyazaman, Kamruzzaman and Sikandar Ali, the Pattadar raised objection
Pattadar raised as a lawsuit notice, not asked.
against such mutation for which the names of Bakhtiyazaman and Kamruzzaman deleted from the Patta while the CS Patta number 97 converted to RS Patta number 137. But the names of Sikandar Ali remained recorded due to omission and taking advantage of remaining the names of Sikandar Ali, Bakhtiyazaman and Kamruzzaman again got their names mutated in the record of rights along with the daughter of Sikandar Ali showing the heirs of Sikandar Ali. Exhibit 2, certified copy of the Jamabandi of RS Patta number 137 supported the contention of the plaintiffs. Exhibit 2 also indicates that on the death of Qasim Ali, instead of mutating the name of his sons Abdul Aziz and Abdul Hai, the names of Idris Mia, Ayatun Nessa, daughter of Abdul Rahim, names of Abdul Rahim, Abdul Rahman and Sikandar Ali were recorded wrongly, showing heirs of Qasim Ali. It is almost the admitted position that Sikandar Ali not the heirs of Qasim Ali. On the other hand, the defendants failed to adduce any reliable evidence to show that their predecessor in interest, Sikandar Ali, Bakhtiyazaman and Kamruzzaman got their names mutated in the record of rights legally. Thus, the aforesaid discussion clearly goes to show that the predecessor in interest of the defendants and thereafter the defendants got their names in the record of rights in CS Patta number so-and-so, RS Patta number so-and-so, and second RS Patta number 215 in respect of 5 Katha 7 Chataks of land covered by Dag number CS, Dag number 688, part of RS Dag number 527 and also part of second RS Dag number 634 illegally and collusively. As such, the said mutation liable to be cancelled.
let us see the findings of the appellate court on these two issues, 2 and 5,
Issue 2, page 14, Lordship.
1-4.
1-4.
Limitation part. Limitation,
Last.
limitation.
Yes, Lordship. This issue is decided by the learned lower court in negative against the defendants. I have gone through the discussion of the learned lower court of this issue, wherein it was discussed that the mutation of the predecessor in interest of the defendants Sikandar Ali Bakhtajaman and Kamruzzaman was recorded in the year 1930, that is more than 80 years back. It should be 1913 motion. And the plaintiffs pray for cancellation of such mutation and also observe that defendant Abdul Mannan, Abdul Hannan and Ibetun Bibi also got their names mutated in the suit patta all about 17 years back. And the plaintiffs did not raise any objection. The learned court below observed that the plaintiffs remain all along in continuous possession of the suit land and not aware of the fact that the defendants had their predecessor interest illegally and collusively got names recorded in the suit patta till the year 1994, while the principal defendants take their claim over the Schedule B land in the guise of false collusive mutation and threaten to dispossess from the same. This collusive mutation came to the knowledge of the plaintiffs while they made inquiry on lordship in the year 1994 and 96 by obtaining the certified copy of the relevant documents, and Exhibit 1 to 4 are the certified copies of the same. As such, the learned court below, while discussing this issue, observed that as per Article 59 of the Limitation Act, the period for 3 years to cancel and set aside the instrument or decree started from the date of knowledge about the fact of instrument or decree sought to be cancelled. I have gone through the Article 59 of the Limitation Act and also Article 110 of the same Act. The Article 110 provides limitation of 12 years from the date of knowledge of exclusion when a person is excluded from a joint property to enforce a right to share therein. From the pleadings of the plaintiffs, the admitted position is it was a joint family property and they claim the right, title and possession over the same. Considering the above facts and circumstances, I find that the issue decided by the learned lower court is rightly and properly, and it is nothing to interfere with the decision in this issue. Without any pleading, lordship, learned first appellate court goes ahead, lordship, saying that it is a joint property, lordship. And the plaintiff
No, but that, you're right in contending that that part of discussion is not relevant.
lordship,
But it is not denied that the limitation is 3 years.
lordship.
Even excluding this discussion that it's not a.
Limitation is only 3 years.
3 years.
Lordship.
But we may not be too much impressed with this
Lordship.
last part. We will
But these are
be
purpose
agreeing with
finding,
you.
lordship.
It's not a joint property.
Lordship.
But the earlier discussion that the
Date of knowledge,
plaintiff has
lordship.
got the knowledge from December 1994, that may be relevant to the issue.
Lordship,
Because whether joint property or otherwise, it's not in dispute, it is 3 years.
lordship,
So you have to, even excluding the later part of the discussion,
lordship,
there is no dispute to the fact that the limitation is 3 years.
lordship.
So we have to examine whether this 3 years limitation, the findings arrived at, are based on the evidence of record.
Lordship.
Now, Planet First Appellate Court has said that on obtaining the certified copy from December 1994 to May 1996,
Lordship.
they could come to know about this collusive or whatever they call mutation, and therefore the suit was filed thereafter.
Lordship. But from the pleadings of the plaintiff, your lordship will not find any averment in regard to their knowledge when we try to dispossess them, when the threatening occurs, lordship. It only states that the principal defendants threatened to dispossess the plaintiff from a portion of their homestead land measuring about 5 katha 7 chata. There is no date mentioned, lordship.
96, I think. I was found somewhere 96.
No, lordship. Then
I think 96 somewhere we found.
no, lordship. Last part, lordship, page 87, they stated that the cause of action arose on and from different dates of obtaining the certified copies. Before that, they have stated that page 85, the principal defendant threatened to dispossess the plaintiffs from a portion of their homestead land measuring about 5 katha 7 chata.
In the evidence,
There is no mention of any date, lordship.
in the evidence, there would be,
PW1.
in the evidence, there would be some date, some year or date that There was a threat of disposition. Because see, merely getting the certified copy, they'll not seek for certified copy unless there is an attempt from your part to dispose of them. Then they may be curious.
If we attempted in the year 96, they
96 will not be a
Lordship,
logical.
they
It has
applied
to
for
be
certificate in the year
before
1994.
94
Yes, Lordship.
or in 94 because December 94 was the first certified copy.
Lordship.
So when you had
Immediately-
made an attempt to improve
Immediately when they threaten, we obtain.
Yes.
Therefore, it is 94.
94. Now, have you stated anywhere in
Yes,
the
we said plaintiffs are in peaceful possession of the food land along with the other, being threatened and dispossessed, they obtain the certificate. Threatened to dispose, they obtain the certificate.
When?
Therefore,
Oh.
Huh?
Have you stated it? Have you mentioned any date or year or time?
No, here, if the paragraph following, then we said we obtained certificate, cause of action arose from the different date from 94. So it is apparent may not be 94. only. They threatened and therefore we obtained. And date of obtain is 94 apparent. may not be
December 94.
94.
Okay. And let us see the discussion of what do you see? What is it?
PW1, Lordship.
No, collusive that.
Lordship,
issue
Lordship.
five.
Issue 5, Lordship.
Issue 5, so you will come, you will get at the page.
Last,
Six.
last page, Lordship, page 19.
Affirmed, my lord. Since the
Issue number 5 is
Findings are-
decided by the learned lower court in affirmative and in favor of the plaintiffs. I have gone through the discussion of this issue and find that the learned court below has rightly decided this issue by observing that the alleged mutation was done behind the back of the knowledge of the Pattadar Idris Mia and Hauni Bibi, and also decided the collusiveness of the mutation. As such, I do not find any interference with the decision of the learned lower court in this issue. Idris Mia Hauni Bibi never objected, Lordship. Whether they can prove that Idris Mia and Hauni Bibi objected, Lordship.
But that was the finding of the first court, that the objections were by the Pattadars, which
Lordship,
Mr. Roy has pointed out.
Lordship.
Objection was by the Pattadars.
yes, but not us, my lord. Then 80 years back, 100 years back, how can it-
Whether that was proved, Lordship. And
Okay,
in
But
PW1,
no, whoever has objected, you have not, the fact of cancellation of the rest of the names except Sikandar is not disputed by you. That is a very significant matter.
that Lordship.
Maybe you are right that they had not objected, neither the Pattadar has objected. But it is also a fact that
Para 7, Lordship, that they have stated in para 7 of their plaint.
Hmm.
And in regard to para 7, Lordship,
let us see para 7. Page,
what we have stated in page 94, Lordship, in our written statement. That the statements made in para 7
first
of
let
the
us see,
plaint.
first let us see para 7 of the plaint.
Para 7, that the
Page,
defendants, page 82, Lordship. Internal page 6.
Two.
May I read it?
Yes, please.
That the defendant's predecessor in interest, Sikandar Ali Bakhte Jaman, Kamrud Jaman, son of Gabru Mia, collusively got their names mutated in CS Patta number 97, Dag number 688, full, allegedly by right of purchase, in the year 1912 and 13. That objections were raised promptly against the false mutation for which it was cancelled, which is evident from the fact that their names did not appear in RS Patta number 137, save and except the names of Sikandar Ali. Sikandar Ali died leaving behind his daughter Musammat Meherban Bibi, who was married to Usman Ali of Singarban. She died leaving heirs who are impleaded as defendant number 6A and 6B. But from the revenue records, it appears that instead of mutation of the name of Musammad Meharbanu Bibi, wife of Usman Ali. The names of the brothers of late Sikandar Ali were again mutated collusively and most illegally.
Was RS 137 exhibited?
Yes, Lordship.
RS 137 was exhibited.
Yes, exhibit 1 and 2, Lordship.
He did not have your names except Sikandar. Is that right?
My lord.
You stated that after objections were raised, it is evident that names were cancelled because RS 137 did not have the name except Sikandar.
Except Sikandar. And
137
along
was
with the Sikandar,
Was 137 exhibited?
my lord, the deed was exhibited, my lord.
No, no, Patra, RS Patra,
Yes, exhibit to the number.
137.
Exhibit 2, Lordship.
Exhibit 2.
Lordship.
ওটা তো নির্ব না।
Exhibit 1 is RS Patta number 215,
The earlier one.
the latest one, Lordship. Exhibit 1 is the latest one. It will go back to 137 is exhibit 2. Then it will go back to certified copy of CS Patta number 97, exhibit 3.
Okay, exhibit. Yes. Oh, yeah, you want
So
to show some.
para 7, Lordship.
Let us see your WS. You want to show the WS
Lordship.
on para 7. Starts at 90.
Para 7, page 94, Lordship. Para 17 of
Yes.
our written statement, that the statements made in para 7 of the plaint are not true and correct. It is absolutely false to state that defendant's predecessor in interest, Sikandar Ali Bakhtajaman Kamruzzaman, son of Gabru Mia, collusively got their names mutated in CS Patta number 97, Dag number 688, allegedly by right of purchase in the year 1912 and 13, and that objections were raised promptly against the false mutation and that for which it was cancelled. And that which is evident from the fact that their names did not appear in RS Patta number 137, save and except Sikandar Ali.
It's a denial.
Yes, Lordship. It is not a fact that Sikandar Ali died leaving behind his daughter Musammad Mehar Banu Bibi. It is absolutely false to state that the names of the brothers of late Sikandar Ali were again
We have read,
mutated,
we have read.
Lordship.
There
So
is no admission.
collusiveness, we
There is
have,
no admission.
Lordship. Collusiveness also we have denied, Lordship. So,
And the,
It is the duty of the
and the matter of raising objection also you have denied.
Lordship.
But you have not said anything about RS 137. You have not said that 137 included the names of all. three. Okay, you wanted to show some decisions, madam?
Yes, Lordship. For limitation part, Lordship.
Yes. Yes.
For limitation part, Lordship, in the Supreme Court of India, State of Odisha and another versus Lakshmi Narayan Das, Lordship.
Citation? Citation?
Yes. Citation, Lordship, 2023 legal SC 694. I have taken it from legal. Lordship. Para 2 and para 54 are relevant, Lordship.
State of Odisha. Versus Lakshmi Narayan Das.
In that case also, writ was filed by one Lakshmi Narayan Das regarding cancellation of revenue records, Lordship.
Civil Appeal 8072. Okay. Disposed of 12/7/2023. Yes. Paragraph,
Para two, Lordship, briefly, the facts of the case available on record are that a writ petition was filed by Lakshmi Narayan Das, dead through LR Satyanarayan Das, Birenchi Narayan Das, on 27/6/2008, challenging the order passed by the settlement officer in settlement appeal number so and so in 1990 appeal, Lordship. The writ petition was filed more than 18 years after the impugned order was passed. The grievance raised was that
bring the, come to the
page, last part, Lordship, last page, 54 paragraph. Conclusion part is there. Lordship.
4 years.
Considering the factual circumstances and the law laid down by this court, the answer to the three issues framed in para number 22 is as under. There is a huge delay on the part of the respondents to avail of their appropriate remedy against the final publication of record of rights. Hence, the respondents are not entitled to any relief.
Where is the ratio which you are trying to apply in your case?
Lordship,
This
on
is
the
the
very
normal case where delay was there on the ground of limitation. It has been interfered with.
On the very beginning, Lordship, it held by Supreme Court the issues which require consideration by this court in the present appeal would be effect of delay and laches in availing the remedies against the final publication of record of rights. So conclusion was made, Lordship, if there is delay, Lordship, that is not maintainable, Lordship.
Now here, your endeavor has to be made that their attempt to show that the law of limitation would not heed their suit is by their reading that knowledge was obtained in the year 1994
Lordship.
after certified copy. In that line, you show some decisions. These are settled principles, statutory principles.
No, Lordship,
by
revenue
limitation
record,
code.
Lordship, our names were
Any
recorded.
case law which is on the fact that the fact of knowledge is something which has to be pleaded, the degree of proof should be, what is the degree of proof? By mere statement? Or how is it to be proved?
Lordship,
Your case is that it is barred by limitation of 1994.
Lordship.
The
There
mutation
is
was
no
done.
such specific pleading by the plaintiffs in their plaint that from this date it came to our knowledge, Lordship, only says while obtaining certified copy, Lordship.
No. We have not heard Mr. Roy, but he has told that on being patent, certified copy was obtained in the year 1994.
Lordship,
So the fact of obtaining certified copy is preceded by the fact of threatening. So we may not insist upon a particular statement that on such and such date.
Lordship. And Kasem Ali, Lordship, after the death of Kasem Ali, his legal heir's name ought to have been recorded in the revenue records as per their para 8A, Lordship. Kasem Ali died before 1971 or 61, Lordship. From Jawabandi, we came to know their sons' names were mutated in the revenue records, Lordship. কাগজ পঞ্জি জমাবন্দিখন দেখাইছিলে এটা পেজ দিছিলে এইটো কলমটো উঠাওচোন কলমটো
No, see, they are not claiming right over the land by any inheritance. Their simple case is that they had purchased from Asia Bibi.
whether Asia Bibi has any right while selling that land.
That is not your case, that their vendor did not have any interest right.
Lordship.
Their sale deed, registered sale deed is not the subject matter of challenge in any counterclaim.
We have denied their purchase, Lordship.
No, denial is a different matter.
So it is the duty of the plaintiff to prove their
No,
case.
there is a
Lordship.
registered deed. If you say that the registered deed, the vendor did not have any transferable right, title or interest, you have to make a specific.
When there is a denial, Lordship, it is their duty to prove their registered
Now,
deed,
once they
Lordship.
have proved, simply by denial, it will not go to the extent of cancelling the deed.
Lordship. But their purchase.
You are
they
saying
ought to
that
have been-
it's denied. You have not said that the vendor did not have any transferable right, title or interest. So therefore, that the deed is known as in law.
They are,
No counter claim.
they are specifically regard to.
Okay, and any other judgment?
In regard to lordship, that order 6 rule 4 lordship.
Yes, yes.
Vishnu Deo Narayan lordship. And Varanasi Sanskrit lordship, 2 judgments. 1977, 1 SCC 279. 3 judge bench
One
decision
SCC.
lordship is para 9. It's
One FCC,
1977, 1 SCC, page 279.
Varanasi.
Varanasi Sanskrit Vishwavidyalaya and another versus Dr. Raskishore Tripathi and another. Para 9 lordship. Page 283, last paragraph. It discussed about Bishan Deo lordship Narayan, that also I have handed over to you, 1951 SCR 548. The 5 judge-
Paragraph 9.
Yes, lordship.
Yes, please read.
It discussed about Bishan Deo lordship, that is 5 judge bench decision. I have handed over 1951 SCR 548 lordship. General allegations are insufficient even to amount to an aberrament of fraud of which any court ought to take notice. Lordship. However strong the language in which they are cast may be, and the same applies to undue influence and coercion. We have already set out the general allegations of alleged collusion by which the plaintiff respondent seemed to imply some kind of fraud. He indicated no reason for this and made no specific allegation against any particular person. Apart from some suspicious surrounding the alleged alterations in the recommendation of the selection committee, only that para 9 is sufficient, lordship.
And this, Vishnu Deo,
Vision Deo, para 27, 28, lordship. 27 says we turn next to the questions of undue influence and coercion. Now it is,
27, 28.
yes, lordship. We turn next to the questions of undue influence and coercion. Now,
That is the quotation from this.
lordship, it is true that these are not separately pleaded.
Okay.
And relying on these judgments, lordship, this is my one of the case where I argued, lordship. This is RSA 9/2009, 2007. Para 14, lordship, regarding fraud. This is also a concurrent finding. In absence of respondents, this court, lordship, allowed the appeal. And there also we are defendants. Both the courts decided against the defendants. In this matter, I appeared, lordship, and after issuing notice, the defendants did not appear, lordship.
Para 14.
Para, lordship, 14, lordship.
Yes,
In that case, your lordship will find in the first paragraph, lordship, after taking dusty service also, the respondent did not appear, lordship.
then it's okay.
Lordship.
What was the,
So para 14, there is a discussion about fraud in all this, lordship. In that case, lordship, concurrent findings were set aside and the suit of the plaintiffs were dismissed, lordship. So these are the judgments in regard to orders 6 rule 4, lordship. And as the question of law is a question of fact, lordship, my learned friend on earlier occasion said that it's a question of fact, lordship. Matter
Which
of
one?
facts, law of limitation, lordship.
it's a mixed question of law and fact.
Lordship.
No,
So in that regard, lordship, I have taken one decision 1984.
no, these are not disputed.
So even in concurrent finding, if question of facts where lordship concurrently held against the appellants by both the courts, that can be reversed, lordship. So these
No,
are,
only because there is a concurrent finding, we cannot exercise powers of second appeal. That is not, even in
as per
concurrent,
this judgment, the High Court has, lordship
otherwise,
reverse
there
those-
would have been a law that in concurrent findings, limited, second appeal is not maintained. That is not the law.
Lordship,
It depends on the facts and circumstances.
lordship.
But the presumption is against you. That since
Lordship.
there are concurrent findings of that, two
Lordship.
courts have come to a finding of fact, then an appellate, second appellate court may be slow in interfering.
For
in
that only your lordship is sitting here, lordship. If there is perversity, your lordship is required to reverse those findings, lordship. And from both the discussions, your lordship has already find the courts itself goes into discussing about the knowledge.
What is that?
Lordship 1984 SCC 255. This is Madan Lal, lordship.
1980.
84 SCC 255. Okay,
Para?
para lordship, that is para 2.
This is on limitation.
No, regarding a Hindu law adoption, lordship.
No, no, point is on limitation.
No, no.
Ratios
lordship.
on limitation.
No, no,
And-
lordship. That was High Court's interference with questions of fact, lordship.
Okay,
Whether the person executing a deed of adoption was in a fit or mental state at the time of
it's okay.
executing.
We're not going to the fact that you said that even,
Whether the
even
question,
cases of concurrent findings of fact.
lordship, High Court has ample point. I have a extra copy, lordship, may I submit? So my humble submission and moreover, lordship, the PW one also admitted in his evidence. Only one PW lordship plaintiff reduced his evidence as PW one and
This is
he
paragraph what?
paragraph 2 lordship.
Now to paragraph 8. Paragraph 8 of the judgment. May we add that this judgment properly understood will not be a charter
Yes,
for
lordship.
interference by the High Court with findings of fact recorded by the final court of fact.
Lordship.
The situation here was an exceptional character where evidence which was incapable of supporting more than one conclusion was considered as justifying a conclusion which no reasonable tribunal could have questioned.
Lordship.
It's a caveat,
Lordship.
in spite of saying that it can be interfered, but a caveat has been done. That
Right.
this judgment has to be taken as an exceptional case.
Right, but here also, Lordship, there are so many judgments also, Lordship, which says even in concurrent finding of facts, Lordship, if the pleadings and evidences were not considered by both the courts below, Lordship, properly,
Yes.
then the High Court had ample jurisdiction under section.
Yes,
1,
yes.
Lordship.
Okay. Mr. Roy.
Wait, please, Lord. My lord, I'll be very brief, my lord, because only two issues, limitation and the fraud
We
part.
can do one thing, we'll take a break. How long will you take? Half an hour?
Half now,
Okay, we'll take the break and come back.
lordship.
You're relying on a case clause.
Only one, my lord, one or two.
Okay, 5 minutes.
My lord, I think I must correct one fact, my lord. Lordship, kindly come to page 42. About my purchase. In fact, I purchased it. I said earlier, Ashia baby. It's actually Laila baby, daughter of my sister of Ashia baby. I'll replace 42, my lord. I have given
Just-
my page 42, where my lord,
Just a minute.
I think facts must be corrected, my lord. While
Oh, Laila Hazi.
my lord,
Laila Hazi.
Laila Bibi, it's a Hazi and Bibi, but she must be Hazi.
Laila is also a daughter of Idris.
Yes, same. Now, my lord, may I read it, my lord, or
Okay, okay, that's a fact. We are not, still not
facts are-
disputing.
from our successor.
Whether you buy from Asiya or Laila, they are sisters.
Doesn't.
Laila.
So, my lord, so far as this suit land is purchased from Laila. Now, my
Laila,
lord,
Laila Hazi or Laila Bibi?
Laila Bibi, the trial court judgment says Laila Bibi.
Laila Bibi.
Lord.
Okay. Yes, tell us.
Now, my lord, I'll confine myself on the points asked by my learned friend, my lord. My learned friend has raised the question of limitation. My lord, apart from the Lordship take up the Limitation Act, my lord, what about? Apart from Article 59 and 110, my lord, Limitation Act, if Lordship kindly have a look at.
L. Welcome. Limitation L. Right. Yes.
My lord, Lordship will come to take the section 17, my lord. I rely on
17.
section 17. 17.
Effect of fraud.
Or mistake, my lord.
Yes.
Where in a case any suit or application is for which the period limitation is prescribed by this act. A, the suit or application is based on fraud of the defendant or respondent of the so, then knowledge of the right title on which the suit application is founded is concealed by fraud or any such person aforesaid. The suit or application is for relief of the consequence of a mistake where the document necessary to establish the right of plaintiff application has been fraudulently concealed. The period of limitation shall not begin to run until the plaintiff or the applicant has discovered the fraud or mistake with reasonable diligence, have discovered it And in the case of concealed document, until the plaintiff applicant first had the means of producing the concealed document, compelling production. So, now, my lord, I just have one recent decision of the Supreme Court on this, my lord. My lord, I couldn't get the SSC copy. It is reported in 2022 8 SSC page 401. This deals with both, my lord, the limitation 17 and the pleading required under Order 6 Rule 4. My lord will kindly take up, come to paragraph 10, paragraph 10. The page, my lord, is nice.
Saran Pal.
Charan Pal. This is reported in SCC, my lord, 2022 8 SCC
401.
I could get this copy, my lord, Manipatra.
Paragraph?
Para 10 onward. Only 2 paragraphs I'll read, my lord, and up my submission. Paragraph 10, my lord, where the section 17 is quoted.
Yes, please.
Para 10. As per Article 58 of the schedule limitation, a suit for declaration where Article 56, 57 do not apply, the plaintiff should file within a period of 3 years when the right to sue first accrues. On applying the Article 58 to the prayer for declaration, the sale deed dated 23rd 1969 is invalid. The suit filed after 42 years on 27 March 2012 is clearly barred by limitation. However, though not adverted to the impugn order, the division bench and the order of the single judge of the High Court, it is apparent that the plaintiff, for the purpose of decree of declaration that the sale deed dated 23rd August 69 is invalid, relies on section 17. So when section 17 is quoted, I have read before lordship. Next page, my lord, kindly stay, kindly come. The general principle which also manifests itself in section 17 of the limitation is that every person is presumed to know his own legal right and title in the property, and if he does not take care of his own right and title to the property, the time for filing the suit based on such right or title of the property is not prevented from running against him. The provisions of section 17(1) embody the fundamental principle of justice and equity, namely that a party should not be penalized for failing to adopt legal proceedings when the facts or the documents have been willfully concealed from him, and also that a party who had acted fraudulently should not be given the benefit of limitation running in its favor by virtue of such frauds. However, it is important to remember that section 17 does not differ the starting point of limitation merely because the defendant has committed the fraud. Section 17 does not encompass all kinds of frauds, but specific situations covered by section clause A to D that I've read, fraud, etc. Section 17(1) of the Limitation Act. Section 17(1) and D encompasses only those fraudulent documents and acts of concealment of documents which have the effect of suppressing knowledge and entitling the party to pursue his legal remedy. Once a party becomes aware of the incident facts necessary to pursue legal remedy, the period limitation commences. Therefore, in the event the plaintiff makes out a case that falls within any one or more of the clauses subsection 1 of section 17 Limitation Act, the period of limitation for filing the suit shall not begin to run until the plaintiff or the applicant has discovered the fraud / mistake, or would with reasonable diligence have discovered it, or if the document is concealed till the plaintiff has means of producing the concealed document so and so. Diligence, now this says there must be diligence, this is described. Diligence is a word of common parlance, means attention, carefulness, and persistence in effort in doing something. This quote in so-and-so versus so-and-so, in reference to the proviso Order 6 Rule 17, defines diligence as follows. According to Oxford Dictionary, the word diligence means careful and persistent application or effort. Diligent means careful and steady in application of one's work and duty, showing care and effort. As per Black's Law Dictionary, diligence means a continual effort to accomplish something, care, caution, the attention and care required from a person in a given situation. The word diligence read with the word reasonable in the context of 17 subsection 1 of the Limitation Act is subjective and relative. It is not it's subjective and would depend upon circumstances which the actor called upon to act reasonably knows or ought to know. Vague clues or hints may not matter. Whether the plaintiff applicant had the means to know the fraud is a relevant consideration. It is manifest that section 17 subsection 1 of the Limitation Act does not protect a party at fault for failure to exercise reasonable diligence when the circumstances demand such exercise and in exercise of which the plaintiff applicant could have discovered the fraud. When the time starts ticking, subsequent events will not stop limitation. The time starts running from the date of knowledge of the fraud or mistake or the plaintiff applicant when required to exercise reasonable diligence could have first known or discovered the fraud or mistake. In the case of a concealed document, the period of limitation will begin to run when the plaintiff applicant had means producing the consent. Now, my lord, if after obtaining, if I would have obtained the certificate 5 years before filing or 6 years before filing, then the matter would be, when I obtained the certificate immediately after a file. So, my lord, I came to know and file. So this is what says, Next, my lord, paragraph 13. Thus, when the plaintiff relies on section 17(1)(b) Limitation Act, asserting fraud or mistake, he has to state the date on which he has discovered the fraud or mistake and also state that he could not have discovered the fraud or mistake with this. This is because Order 6 Rule 4 says, Order 7 Rule 4 says, if there is barred by limitation, then you have to have the ground. So my case is not that. My case is that it is within limitation. If it is barred by limitation, then I'll have to explain the ground. Now, next paragraph 14. Rules of pleadings relating to fraud and exemption from law of limitation are set out in Order 6 Rule 4 and Order 7 Rule 6 of the Code. Order 6 Rule 4 lays down that in all cases where a party pleading relies upon fraud, particulars with respect to the date and time, if necessary, shall be stated in the pleading. The fraud as alleged in the plaint must state those facts and together taken as a whole, if proved, would show established fraud. So court must take all the facts stated, and then if it is shown, sees that that is a fraud, it is not necessary that each item should be given, because the provision also says if and when necessary. Order 6 Rule 4 says date, time, if necessary. That's why it's pleading or fraud or should be conspicuous and palpable and should not be predicated on mere suspicion and conjecture. Of course, the court at the initial stage, when deciding the application under Clause D, Order 7, Rule 11, has to produce with demur and therefore should accept the facts as alleged in the plaint. But can in a given case draw irrefutable inference from the facts stated. Order 7 Rule 6 requires the plaintiff to show the grounds upon which the exemption, this is when the time is beyond limitation. 6, limitation period of claim. And the plaintiff should set out the grounds for claiming such exemption, which means that the plaintiff must state or causes reasonable attributes on the basis. According to the plaintiff, a period should be excluded and not counted. The recitals in the plaint should be specific and comply with the terms Order 6 Rule 4 CPC. Order 6 Rule 6 is liberal, inflexible, while the mandating that the suit instituted post expiry of the period limitation must state grounds upon which exemption is paid. So and so on the grounds and inconsistent with the grounds set out in the plaint. The proviso does not nullify the requirement that the first place the plaint must set out the grounds seeking exemption for limitation. When and to what extent Order 7 Rule 6 and Order 6 Rule 4 apply, these provisions being specific will prevail over the ground Order 6 Rule 2 CPC. Nevertheless, the requirement of the rule is to plead specific facts with dates but not factual evidence and the basis on which the plaintiff would ultimately seek to establish and justify the claim exemption so and so. When the minimum threshold requirement order 6 rule 4 and order 7 rule 6 is satisfied and met cannot be put in straitjacket formula, as it would depend upon the facts and circumstances, including the antecedent facts. My case is such. And in particular, the relationship between the parties and their predecessors and the period bygone with challenge, without challenge. While the claiming these aspects, especially at the initial stage, clause D, order 11, rule 11, order 7, or order 14, rule 2 code, the court cannot proceed on the basis of assumption as to the evidence that would be led so as to record the findings so and so. At the same time, an artifice or clever drafting should not prevent the court from stopping plainly time-bound proceedings, an aspect we would again advert subsequently. The court can take benefit, order 12, rule 6 of the code, when there are admissions made by the plaintiff in the plain and the documents which admitted the parties, or being not dispute, which would require the oral evidence in the context of the document. There is no bar against the invoking provision order 6 rule 11 of the code, order 14 rule 2 together, or even applying the order 12 rule 6 while proceeding with demur. Provisions of the code are not watertight compartments. Unless such statutory constraints is expressed manifestly applied, we would not, have absence of constraint, deny the trial court or the appellate court flexibility in application of the procedural source. This is what I'm saying. My lord, the court will have to see the background. My lord, I have been all throughout in possession. My possession is not disturbed. The document shows that they have fraudulently, my lord, entered the name in the revenue record. So if it is a mutation, there has to be possession, proprietorship and possession. So they are not in possession because my claim is, my lord, confirmation of possession. I mean, also possession. I do not know, because I am not required to go every day to the revenue court to see if anybody has entered, changed my name. So this is what. So therefore, when I came to know about it, when they put a threat on us, then I thought, well, why they are trying to put a threat and wants to dispossess us. Then I went to the revenue authority. Then I found and obtained certificate immediately thereafter I filed. So my lord, it is well. My case is not beyond the period of limitation. I am not required to state the grounds, everything of the delay, because my case, I know I am within the period of limitation. That's why. So my lord, it is, the court will look into the backgrounds of the case, and then it is not a watertight. Order 6 rule 4 is not, my lord, it is not in a watertight compartment. The court has to look into the facts and circumstances of the case, and if the facts given, the court draws an it comes irretrievable inference can be drawn. That it is to be admitted, because my facts are like this, because my possession is never disturbed. They are residing elsewhere. In the pleading, I have said they're residing elsewhere, not near me. So, my lord, there is no question of limitation. So far as the statement are concerned, my lord, my statements your lordship will find are adequate. Adequate. Period of limitation, and if your lordship wants, I can read the relevant para of my plane, where your lordship will find from an inference can be drawn easily that it is the trial court finding. Both the court also came to a definite finding that it is a fraud. So this being a concurrent finding as regards fraud and limitation, lordship definitely would not like to interfere. This honorable court has also, my lord, has had as well, my lord, since in the second appeal, the lordship is aware of that, my lord. Paragraph 9. There is no, my lord, it's rejected on the ground that in the second appeal, the lordship got in para 9, my lord. Mr. Emoshing, learned counsel with the respondent has further contended the suit was barred by limitation. The trial court has given finding that the suit was not barred by limitation. The question of limitation was not raised before the district judge by the defendant. The question of limitation present case is mixed question of law and fact, and therefore we decline to deal with the question in a second appeal.
Where are you reading paragraph
Paragraph 9, my lord.
9?
9. Last. Third page. Last.
Yes. Please read.
Paragraph 9. Mr. Emoshing, learned counsel for the respondent, has further contended that the suit is barred by limitation. The trial court has given finding the suit is not barred by limitation.
But here limitation was taken as the defense, the preliminary ground in your case.
No, my lord.
Question of limitation was not raised before the district judge. Facts are different.
Before the district judge. But-
Here it's taken in the plaintiff.
That's true, but then ultimately,
Trial stage itself in the WS.
but it said it's a question of, my lord, it's a mixed question. The ratio, the question of limitation is a mixed question.
Yes, big question.
Therefore, my lord, lordship, this being because I have said, lordship will look into every question of fact, which is already decided. Question of fact has been decided by both the courts below.
This ratio may not help you.
Anyway,
It's a
my lord,
different matter to contend that since a question of mixed question of law as well as fact have been decided concurrently by two courts, the scope of interference may be minimal. That's a different
lord,
argument.
whether lordship is right, but whether it's a limitation or other, on this question, a limitation or otherwise, when both the courts are concurrently has held, my lord, lordship will definitely would like to.
Have you got a straight decision on this? Concurrent findings of
Often, my lord,
concurrent finding and
Oh,
second
yeah.
appellate court should go slow.
my lord, there are many, my lord, immediately I'll give you a lot to that. There are many, my lord, concurrent finding, even so Santosh Hazare perhaps, my lord, explains it quite well, Santosh Hazare. 2001, 3 SSC 179. My lord,
Please the decision.
No.
Yes, ordered. Shows that finding or shows the averments in the plain.
lordship. আমার পেছনে ওইটা তুই করতে পারবেন না। My lord,
Plaint is at 82, it
Para
comes at
7.
page 82, paragraph 7.
para 7, yes.
Page 82.
882, para 7. My lord, defendants, predecessor in interest, Sikandar Ali, Bakhtar Jaman, Kamrud Jaman, son of Gabru Mia, collusively got their names mutated in CS Patta number 97, Dag number 688 full, allegedly by right of purchase in the year 1912-13. That objections were raised promptly against the false mutation for which it was cancelled, which is evident from the fact that their names did not appear in RS Patta number 137, save except the name of Sikandar Ali. Sikandar Ali died leaving behind his daughter Musammat Meherban Bibi, who was married to Usman Ali of Singarban. She died leaving heirs who were impleted defendant number 6A and 6B. But from the revenue record, it appears that instead of mutation of the name of Musammat Meherban Bibi, wife of Usman Mali, the names of brothers of late Sikandar Ali were again mutated and most illegally suppressing the truth. Well, this is self-evident that after the death of Qasim Ali and his heirs, his sons Abdul Aziz and Abdul Hai's name ought to have been mutated, but instead of the name of his brothers together with Sikandar Ali, led Gabrumia was mutated most illegally. Sikandar Ali's name cannot be mutated even by any stretch of imagination which is apparently fraudulent. that Abdul Rahim died leaving behind his wife Muhammad Salim Bibi and two daughters, namely Shiramjun Nisha and Muhammad Hayatan Nisha, and their names were accordingly mutated in the record of rights maintained by the SDC's office. But most interestingly, by entry number 1, RS Pattanam 137, it appears that the names of Idris Ali, Hayatun Nisa, Abdul Rahim, and Sikandar Ali's name was mutated by purchase. Abdul Rahim's name cannot be mutated by the right of purchase as he died long before, and as such, the entire mutation is false and fabricated and collusive. At the instance of Sikandar Ali, Abdul Rahim died leaving behind two sons, Abdul Jabbar alias Jabbar Uddin, Meheruddin, and daughter Samsun Nahar Meheruddin died leaving behind daughter Muhammad Haru. That by entry number 3, it is apparent, it appears as after the death of Sikandar Ali, two daughters, Kamaruzzaman and Bakruzzaman's names were mutated instead of Meherban Bibi, his daughter. That by entry number 5 of Jamabundi, it appears that certificate case number 5 disposed on 21/4/34, land measuring 4 katha, 11 chatha, 10 gandas was auctioned and purchased by Abdul Mia, son of Hassan Mia. The entire matter is fake and fictitious. There is no person Abdul Mia by the name ever exists and existed in the locality to the best of the information. It is homestead land under occupation of the plaintiffs. Even assuming and the correctness of the certificate case of Ramjudwan could not part with so much share as shown in the certificate's case, and assuming further after the certificate case, this remains land of one katha only. The defendants reside in a Dag 650, which is contiguous to Dag number 634 of RS Patta number 215, and as such, there is apprehension. Apprehension. So, my lord, this paragraph 8A, B, C is from 7 onwards, indicates apparent, my lord. Apparent. The court can draw inference. It's from it.
It cannot be said that pleadings are not there on.
No, it cannot be said.
Fraudulent activity pleadings
If
are
at a
there.
one line pleading, that would be different. It is not one line pleading. Adequate.
It's not a very general or a vague statement.
No. Specific. Sorry. That's another one. Concurrent finding and nothing else. Well,
Ultimately, when were the names mutated? The fraudulent activity, when was it done? By which order? The 12-13, there was an attempt. There were objections from the Patadar. You said it was cancelled, and
yes.
such cancellation is evident from the subsequent RSA Patta 135, where the names were not there except Sikandar.
My lord, I think, my lord, lordship sees page 42. Page 42, my lord.
42.
Yes,
What is there?
42, my lord, the fourth line. These are the lordship will find.
Yes, please read.
Plaintiffs also claim that they have acquired right title interest over the land under dispute by way of inheritance, and their predecessor Abdul Chanso, Abdul Hai, and also got the same right inheritance from their father Chanso, and also a right to purchase by Laila Bibi, daughter of Idris Mia. In support of the claim, plaintiffs filed a registered deed number.
Your purchase is not the only source of your right.
Right, by inheritance also.
You purchased a part of the entire land from Laila.
Yes.
Some parts you had inherited from your predecessors.
Yes. So, my lord-
Where is your statement?
My lord, I read further, my lord,
No, this is a part of the judgment.
judgment, my lord. In the
Plain,
plain, oh, my lord, specific date cannot be taken.
it starts at page 80.
Which of the figure? My lord, the document, I have annexed, I mean, I have exhibited the.
Document we are not very interested. Come to 79, it starts.
My lord,
The source of your right.
17.
Plain stands at 77, isn't it? Plain 77. Plain.
Plain,
Yes. In the plain we want to see.
plain, my lord,
Starts at 77.
My problem is this copy is not very readable. Paste.
77 it starts, 79 are the first paragraph.
Oh, yes. Yes,
Yes. Which part?
mutation here to the এটা তো আছে কিন্তু এটাতে when the name
Para 7 last 3 times, but the year was not
para 7.
second time they written here.
Yes, the year was not mentioned here.
Okay, no, we just now we have read part of the judgment that you got some part from inheritance, some part you purchased from Laila Bibi. Where are those statements? Yes, in paragraph 4. Paragraph 4, page 81. Please read.
Paragraph
Sabu Mia and Gabru Mia.
Sabu Mia, Gabru Mia were brothers. Sabu Mia died leaving behind 4 sons. They are Idris Mia, Qasim Mia, so and so. Amongst brothers, Qasim Mia died leaving behind 2 sons.
They are Abdul Aziz and
both
Abdul
Aziz
Hai.
Abdullah living behind plaintiff. Idris Mia living behind daughter son.
Both Abdul Aziz and Abdul Hai died leaving the plaintiff.
Plaintiff.
So your inheritance. Then Idris Mia died leaving only 2 daughters. Ashia and Laila. Plaintiffs purchased their share by registered sale deed. Then your purchase is good from Laila and Ashia.
No, only Laila. Ashia transferred to Laila then we purchase from that.
That means, Abdul, you are the, one second.
We are the sons of
Just a minute. The plaintiffs are the sons of
Abdul Aziz.
Abdul Aziz and Abdul Hai.
Abdul Hai, yes.
And Abdul Aziz and Abdul Hai are the sons of Qasim.
Lordship.
Okay, so through Abdul Aziz and Abdul Hai and thereafter from Qasim, you inherit the
Lordship.
on one part, and
One
the
part.
part which was which had fall into the part of
Idris.
were devolved upon Talen, Asia and Laila. Asia had transferred her right to Laila, and from Laila you had purchased.
Lordship, right.
And
Correct.
so far as Hauni Bibi is concerned, Talen's wife, what has happened to her share?
Talent, I think Talent Mia actually died.
No, Talen had died.
Hmm.
Hauni is his wife. Hauni Bibi. Because their contention is that Idris and Hauni had sold the land to Sikandar, Bakte and Kamruz.
But they could not prove it, my lord. They said they have no document to prove it. They have no document.
Is the entire Sut land initially owned by Sabu and Gabru? Entire
Yes.
Sut land?
Yes, yes.
Entire Sut land?
They are the two brothers, my lord.
Then a question may arise
So,
whether
Sabu
whether
Mia-
Idris and his daughter-in-law Hauni could have sold the entire land to Sikandar and Bakte.
I think my lord, part land, which is in UP, I think. Part of the land.
No, it's the entire land. Yes.
We have exhibited all the documents. They have exhibited none.
What documents did you exhibit?
All the sale deeds, my lord. I have read, my lord, just exhibit 1 to 11. Exhibit 1, second, patta number 215. Exhibit 2, patta number 137. Exhibit 3, patta number 97 of Jamabandi. Exhibit 4, patta number so and so. Exhibit 5, sale deed.
Which sale deed?
Sale deed of Salahuddin to Imam Bibi. My and exhibit 6.
You have purchased it from
Exhibit 6.
Laila?
Yes, exhibit 6 and 7.
See, one thing would ultimately come up. Mutation can be granted both on ownership as well as on possession. Their name, they claim that their names are in the records of right. That means it can be presumed that they are in possession. However, the suit is not instituted by them, saying that you have been trying to dispossess them. Rather, on the other hand, your suit is not for recovery of possession. Your suit is for confirmation of possession and injunction not to disturb you. There appears to be a contradiction. If, madam, you say in the records of right, your names are rightfully there, then why are you not in possession?
Will not say here in that by the trial.
And if you are in possession of your respective parts
After
without
field
any
report-
dispute, you remain in possession.
field report
They have
only
not
our
said
name
that you have not said that upon your land they are trying to encroach. Rather, it is their suit. They are saying that on taking advantage of your names in the records of right, you are trying to enter into their property only because your land where you are possessing is contiguous to their plot.
They are playing in para 3 last line. If that case Patla number 97 was issued in favor of Idris Mia, son of Tapnia and son of Hamid, wife of late Salen Mia, when they are admitting that the case Patla number 97 was issued in favor of Idris Mia, how they can purchase the share of Idris Mia alone.
Okay, anything else you are concluding?
There no pleading in the plain lordship, how they purchase which share they purchase. Once they are admitting that it is me and how they will be our owner, and in another paragraph they are saying that we have purchased from it. Who is it? It is me
Oh.
from.
Okay.
But that is not a substantial question of law.
The trial and the constituted court lordship is more than the pleadings pleaded by the state. So my humble submission there.
We are reserving the judgment. MS R. Chaudhary. When it comes for the appearance, whereas the respondents are represented by Sri T.K. Roy, Learned Sine Counsel, assisted by Sri MS Chakup, S.K. Chakup. The hearing is concluded. Judgment is reserved.
I'm deeply obliged.
Obliged.
This is a cross objection on our part.
Yes, process is also there.
Yes.
2010 matter.
2010 meeting. What day after tomorrow, lordship? What day after tomorrow?
Day after tomorrow is a holiday.
Or day after tomorrow, 18th,
On Monday,
Monday.
this court has been informed that there is a talk of compromise going on and perhaps the dispute has been settled amicably. When it comes for the parties, therefore, seek some time to obtain instructions. etc. However, considering that this appeal is of the year 2010, while adjournment is granted, office is directed to list the same on
21.
24.
Obliged.
Yes, what is this, Mr. Upadhyay?
But I was, a time was given to me to take an instruction from my client about how much time she required to vacate.
Yes.
So it is, our expectation of my client, expectation of my client is very high. It is up to lordship how much time.
Now, how high?
She has been doing this business in the premises since 2004. And
Now,
she has,
what is the high expectation? Let us see. How much?
how much is the expectation is 3 years, but it is not possible. I told her that it is not possible.
3 years on marriage, will be able to dispose
Yes,
this out.
yes, of course. Anyhow, your lordship, up to your lordship, but generally, in other cases, 9 months like that, up to 1 year, I have seen. 9 months. yeah.
The
Up to your lordship.
initial decrease of which year? Initial decrease of which year? Initial decree is of which year?
Decree was passed,
Fruit of 2016,
yes.
And decree?
decree 2020.
Recent decree.
From 16 to 2023, you are successful.
Your lordship, up to your lordship,
4 plus 3,
how much time will?
7 years. Yes, Mr. Iqbal, what do you say?
My lord, let him stay till December, man. New year, new
He is
beginning.
very
man.
liberal, he is very liberal.
We'll start the new year with a new beginning.
This September, October, November, December,
It will be very short,
4 months.
almost, will be very
Okay, we'll have it 6 months.
short. Minus 9 months at least.
6 months. He's saying 4, you are saying 9. You
9
should have
months.
told more.
No, in other
The
cases.
mean would have been more.
My
We
lord,
have taken the
I'm
average.
not saying more. It is reasonable, it will be reasonable. It is, she is a lady.
Yes.
And she has to manage. She
Both
has
are
a very
ladies, my
difficult.
lord.
Ah,
Landlord
Even
is
her, she is a lady.
a senior citizen.
Okay, hi,
Up to your lordship.
3. This is the item number.
But one
51.
thing, my lord, he will accept our rent. Now I am depositing in the court. So he will directly, we shall pay directly.
That is up to him. Why should we
If they
enter?
tender, my lord, definitely, I will. They have not tendered it.
No tender, why not?
D.P. Upadhyay, learned counsel for the petition, whereas Sri A. Iqbal is present for the respondent. Full stop. The instant revision petition has been referred against a judgment dated 28/4/2023 passed by the civil judge number 1 Kamrup M in title appeal number 1 of 2021, by which the appeal has been dismissed and the order and the judgment and order dated
23/12/20.
23/12/2020 passed by the learned Munsif number 2 Kamrup M in title suit number 274 of 2016 has been affirmed. Full stop. The petitioner was the defendant in the suit which was instituted by the present respondent as plaintiff for ejectment on the grounds of bona fide requirement as well as defaulter. Full stop. The learned trial court, by the judgment and decree dated 23/12/2020, had decreed the suit in favor of the respondent plaintiff on the and directed ejectment on the ground, on both the grounds.
Both.
On both.
Full stop. Against the aforesaid judgment and decree, comma, the petitioner had preferred the aforesaid appeal, which has also been dismissed by the learned civil judge number 1, Kamrup, by the impugned judgment dated 28/4/2023. Full stop. Para. The Upadhyay, the learned counsel for the petitioner, has submitted that the findings arrived at by the learned Munsif, which have been concurred by the first appellate court, by the appellate court, are inconsistent with the materials on record. He submits that rent was being deposited in the bank,
No, in the court.
in the court in various NJ cases. And therefore, the question of decreeing the suit on the ground of default of could not have arisen. Full stop. He submits that the findings regarding bona fide requirement are also not in accordance with law. Full stop. On the other hand, comma, Sri Iqbal, learned counsel for the respondent, has at the outset submitted that under the Urban Areas Rent Control Act, comma, there is no provision for filing any second appeal, and it is only because of the state restriction that recourse under section 115 of the CPC is taken. So he submits that powers of revision are to be exercised with circumspection, and only when there is jurisdictional error or patent illegality or irregularity in the judgment, comma, a court exercising powers of revision could be loath to interfere. Full stop. He submits that so far as the instant case is concerned, comma, though the projection made on behalf of the petitioner is that brands were deposited in the court in various NJ cases, comma, the same was not preceded by any tendering of the rent, and such tendering was not proved in the court, which is required under the settled principles of law. Full stop. He further submits that on the aspect of bona fide requirement, comma, it is a settled principle that the landlord is the best judge, and the requirement can be best assessed by the landlord. Full stop. Sarah. The tribal submissions have been considered. Full stop. This court, in exercise of powers under section 115 of the CPC, act as a court of supervision, wherein the primary object is to see whether the judgment impugned passed by the subordinate court is passed suffers from any jurisdictional error. Full stop. In the instant case, comma, there is no such jurisdictional error. Full stop. The other aspects which are to be taken into consideration is as to whether the findings arrived at have been done by taking into consideration the relevant factors, or that irrelevant factors have been taken into consideration. Full stop. On both the aspects, comma, the judgment passed by the learned Munsif, which has been affirmed by the appellate court, appears to have been passed by taking into consideration the materials on record and the evidence adduced by the rival parties, comma, more specifically by the plaintiff, to establish the ground of default in payment of rent, as well as the bona fide, as well as the aspect of bona fide requirement. Full stop. The aspect of bona fide requirement is an aspect which is best, which should be best left to the assessment of the landlord. Full stop. It is a different aspect altogether that if such requirement is not bona fide and has been raised only as a means to evict. Full stop. However, in the instant case, comma, the requirement appears to be bona fide, and therefore there is hardly any scope for interference by this court in exercise of powers under section 115 of the CPC. Full stop. As regards the ground of default in payment of rent, comma, mere fact of depositing the rent in the court in various NJ cases without establishing that such rent was first tendered to the landlord and refused, comma, the same would not be a valid defense for a defendant in such a case. Full stop. And under the aforesaid facts and circumstances, and in view of the discussions made above, comma, this court is of the opinion that no case for interference is made out. Full stop. At this stage, comma, Sri Upadhyay, the learned counsel for the petitioner, submit that the tenancy was existing since the year 2004, and therefore a reasonable period, and therefore, comma, in case this petition is dismissed, comma, a reasonable period be granted to the petitioner to vacate the suit property. Sri Iqbal, the learned counsel for the respondent, however, fairly submit that a reasonable period may be granted which should not be more than 4 months, and accordingly a direction be granted to vacate the premises by the end of July 2023. Full stop.
December.
After 2020, December 2020. After considering the aforesaid aspect, comma, this court is of the view that while the present petition is dismissed, comma, interest of justice would be served if the petitioner is granted a reasonable time to vacate the premises, which in the opinion of this court is fixed to be a period of 6 months. Full stop. 6 months from today. Full stop. To clarify, to avoid any ambiguity, such vacation should be done on or before. Today is what? 16, on or before 16th of February 2024. Full stop. Till such time, the respondents are directed not to initiate any execution procedure.
CP of Lordship.
Lordship, my senior is at Lex Lordship, and matter may be taken up after some time.
Either?
My lord, he is seeking,
No, what is the matter?
my lord, they have challenged the valuation of the suit.
You are the plaintiff.
Well, I am for the plaintiff and they are the defendants. They said that the suit was not properly valued. And as per the valuation of the suit property, the court is not paid. But the court rejected their prayer, considering that it's a declaratory suit only. So the
It
entire
was for declaration.
only for declaration of
It
correction.
was valued at what?
Valued at or the my lord,
The dispute is for valuation or payment of court fee.
yes, valuation of court fee.
No, there are two aspects. One is how you value this suit, and one is how you pay, what is the court fee you are paying.
My lord,
For a declaratory suit, so court fee is paid.
100 rupees, 100 fee. Only for declaration of correction of records.
And how the objection is with regard to valuation.
Valuation.
How much did you how
My
much
lord,
did you-
foot bill was, my lord, 20 lakh. 20 lakh. But it's a declaratory suit,
declaration of what?
declaration of declaration for correction of record and for permanent injunction. It is the suit, is the object of the
Declaration for correction.
correction of records. Man. There is
How
some,
can there be declaration for correction? Declaration is something else, correction would be a direction.
my
That's
lord,
a consequential relief you would be seeking after the declaration. First, your right is to be declared, then a direction for consequent direction for correction.
my lord. There is some my lord, anomalies in the, some mistakes in the records, and that was sought for correction, my lord. Pursuant this LD, the correction was sought for correction.
Okay, let the other side come with here. And madam, today,
Today, Lord.
suit has been dismissed or what? Oh, his suit. Your application has been dismissed
Yes,
for valuation.
yes, Lord.
Well, how is this? What is the stage of the suit?
My lord, suit was
Suit of which year?
that was of
2020,
2019,
2009.
And this impugned order was passed when?
and my lord, it was passed on to 22,
17, 11, 20.
sorry, 17/11/2022.
There is an interim order over.
No, no interim.
Suit is proceeding.
Yes. In the revision petition, there is no interim, only notice was issued.
What is the present stage of the suit?
My lord, I think, my lord, it is,
Suit is of which year?
my lord, 2019. It is
19.
evidence stage, I think.
Evidence stage. And we'll have it on Monday then.
My lord, will be better.
Oh, a prayer for adjournment has been made on behalf of the petitioner. Vera. Also heard also named 3 years teacher. Learned counsel is present for the respondent. Vera,
1 and 2, my lord.
There are two respondents.
Yes,
okay.
my lord. One and both.
Respondents. Sarah? In the interest of this, list on the page.
Development.
May it please, yes, my lord. My lord, this is a regular first appeal under section 96, my lord, whereby the suit of the respondent for specific performance of contract was decreed, my lord.
What was the contract?
Contract for sale of a plot of land, my lord, 1 bigha, 1 kotha, 10 lesser. That suit was decreed. So my respectful submission at this stage is, my lord, let the appeal be admitted, my lord.
Third 3A equal learned counsel for the appellant who by means of this appeal you may not address the court in appeal. You are not referred.
Right.
This is an appeal to the honorable, it's not referred. Uh, uh, who is aggrieved by a judgment and decree dated 29/5/2023 passed by the learned civil judge Pirang entitled suit number 47 of 2019. The appellant was the defendant in the suit filed for specific performance for contract which has been decreed. Para, admit, para, call for the record. Let's step for service of notice upon the respondent be taken by usual process as well as by registered posted AD. Steps within 2 days. List after 6 weeks along with service report as well as for as well as report on LCR. 41/5.
41/5.
Heard. Yes, so what are your grounds of challenge?
Ground of challenge, my lord, the point of limitation was not at all considered, my lord. In fact, no issue was framed. The agreement for sale was entered into in the year 2014, my lord. And they had filed a suit in the year 2019, which is clearly barred, my lord.
Anything else?
Another aspect is that, my lord, the land falls under tribal belt area. The respondent nowhere stated, my lord, that he belongs to the OBC quota or the tribal belt area, my lord. In fact, a court just picking up one sentence from the evidence has.
Where is the land?
Land is in, my lord, Sigli tribal belt area, my lord, revenue circle.
This is a tribal belt or 6th schedule?
Tribal belt area, my lord. In fact, there is evidence of
Chapter 10.
Chapter 10 of the Assam Land Revenue Regulations.
This is a 6th schedule area. Where is the requirement of bringing in chapter 10? Chapter 10 comes into operation in non-6th schedule area where a protection has been given. Part 3A equal learned counsel for the applicant who by means of this application filed under order 41 rule 5 read with 151 of the CPC has paid for stay of the judgment and decree dated 29/5/2023 passed by the learned court of the civil judge Pirang entitled suit number 47 of 2019, whereby the suit instituted by the opposite party for specific performance has been decreed. The learned counsel has submitted that a specific defense on the ground of limitation was taken, which was not considered at all. Additionally, it has also been stated that the Suitland is in the BTAD, which is a 6th schedule area. And there was no averment on the eligibility of the opposite party to make transaction of immovable property in the said area. Full stop, para. The connected appeal against the aforesaid judgment being RSA number 35 of 2023 has been admitted today. Full stop, para. Issue notice. What is the admitted today? Full stop. Para. After hearing and in view of the aforesaid facts and circumstances, it is direct that pending disposal of the appeal, the impugned judgment and decree that passed with shall remain suspended.
Deeply approved.
Still we have been lordship may admit it. Otherwise,
That apportionment,
lordship,
8 lakh,
lordship.
well, it is clearly not appearing on the last occasion also.
The lordship may fix any other day lordship.
Maybe on Monday next, Monday. None appears for the appellant on call, whereas the respondent railways is represented by Sri K. Gogoi, Planet Series, full stop, para. In the interest of justice, this on Monday. Next, 21st. Same, I think.
Please, Your Worship. Lordship, statutory appeal, my lord. File under section 22 of Railway Claims Tribunal Act. My lord, kindly the appeal may be admitted and LCR may be called.
Who's for the, yes, Mr. Gogoi. What is your grievance, madam?
My lord, the passenger call from the.
Please come again, the dismissal, lordship may admit it, lordship.
Just dismiss it.
Dismissal.
What is your name?
My lord, Zia.
Lord MSC Bezburu, Senate Council, for the appellant who has referred his appeal under section 23 of the Railway Claims Tribunal Act 1987, being aggrieved by the judgment and order dated 12/5/2023 passed by the learned Railway Claims Tribunal, Guwahati,
Lordship, lordship.
Guwahati, in original claim application number. So नाम लिख दीजिए, हाँ? Yes. You अगर है old है new है तो full stop. By the aforesaid order, the claim made by the appellant as claimant has been dismissed.
Lordship.
Full stop, para, admit. Call for the record. Para. Sri K. Gogoi, Senate CGC, appearing on behalf of the railways, accept notice on behalf of the sole respondent. Para, that extra copy of the memo will be served upon him by tomorrow. Para, list of the 6 along with report on LCR.
Lordship. Apology.
Along with report on LCR.
May please be my lord. Lordship, this appeal is prepared by the claimant for enhancement of compensation, lordship. So appeal may can be admitted.
How much has been granted?
Amount granted is lordship 13,03,192 lordship.
How much is your claim?
My claim was 22,30,000.
What do you do? That case, that case.
Yes, that case lordship. Businessmen dealing in rice, etc.
38 R. Agarwala, learned counsel for the appellant, who by means of this appeal preferred under section 173 of the Motor Vehicle Act 1988 has questioned the judgment and award dated 11/11/2022 passed by the learned MACT number 2 Kamrup M within bracket M in MEC case number 469 of 2009. It is submitted that the award is inadequate and the inadequate para admit para call for the record that step be taken for service of notice upon the respondent by usual process as well as by registered post step within 2 days. Please come to 6 weeks along with report report on service as well as on LCF. Yes.
Again, Lordship, this is for injury case, permanent disability certificate is discarded, not taken into account, Lordship. 30% disability was there. And only 45,000 has been awarded for pain and suffering.
The announcement.
Yes, announcement. Lordship.
Announcement. Take an announcement. Sir. Related. Same. Okay, बोलो मैं तो amount नहीं लिख. A claimant. इसमें एक line दीजिए. It is submitted that the learned tribunal did not consider the aspect of disability which was on record. एक line. Yes, steps by today.
Then 9 also, Lordship, same. Disability is not taken into account.
Same accident was.
No other different accident, Lordship.
10.
And 10, Lordship, this is also for enhancement, this is death case, Lordship. And here pain recovery is given.
You are paying for enhancement.
Enhancement, Lordship.
10 is same as allowed.
Again, here, Lordship, this
Huh?
amount has been, IA is there, Lordship, for release of the amount deposited by the insurance company, Lordship. In the order, there is pain recovery, so the amount was not released, Lordship. At least 50% may kindly be allowed to be released. Because this deposit in the MSCT, Lordship.
No, you are filing execution petition.
Lordship, it is deposited, but since the order is there, the owner should give indemnity bond. Then only, so if owner is
Give a
not
bond.
coming. Then why claimant should suffer, Lordship?
You're not, you give a bond just like that, pay and recover.
No, Lordship, the pay and recover, but it is mentioned that owner should give the bond. So claimant is suffering, Lordship. At least 50% may kindly be allowed to release, Lordship.
How much is the amount?
Amount is the 70 lakhs, Lordship, something like that. And order was there for.
Is the award under challenge by the insurance company?
No, Lordship.
Till now, no.
No.
Award is of which year, or which date?
What is 307/2001, Lordship.
2001.
Yes, Lordship. From that amount is lying in the.
When did you prefer this appeal? Appeal is not brought by time.
No, Lordship.
Well,
We applied for the copy and the copy required time, Lordship. In the meantime, insurance company deposited the.
from 7/8/21, it took more than almost 2 years to have the certified copy.
Yes, Lord.
Why?
Because this again, this corona was there. 28 to 2022, it was a limitation period was there, Lord. As per the
No, it is from 9/8/21.
Yes, Lord.
You got the copy in 6/23.
Yes.
Corona was over long time back.
Yes, Lord. 28 to 2022 Lordship.
No, why did it take you?
But there are no, some members were also changed Lordship sometimes.
Is it dependent on the member?
Yes, sir.
Why? Certified copy?
Objection is required. No objection
No objection for what?
for issuing the copy, Lord.
Certified copy.
Yes, sir.
This is, you need to file section 5 application. What is this calculation by the registry? You apply for the copy on 9/8/2021 and you date fixed for notifying the certificate number 10/6. Okay, okay. We'll have this on Monday.
Okay, Lord.
We'll have this on Monday.
Okay, Friday it can be, Lordship.
Friday is a holiday.
Oh. Next Wednesday,
Next
Lordship.
week. Next week. Close this case on 23rd for admission.
11 Lordship, this is also for enhancement, Lordship. The death case, Lordship, for enhancement.
We'll have this on Wednesday.
Okay.
May pleasure.
Just
May please, Lordship.
Yes.
Lordship, my senior is on late in another court, Lordship. This
this is item number
52, Lordship.
52. Come on, though.
Lordship.
Oh, that's the High Court matter.
Yes, ma'am.
Sweeper.
Uh,
Yes, yes.
This is.
not getting salaries.
I have already filed my affidavit, my lord, pursuant to my lord's direction. My lord, we have brought on record, my lord, the office memorandum dated 31st March 2012. Whereby, my lord, there is a clear prohibition that, my lord, the sweeping and cleaning services are concerned, my lord, they have to be out, those services have to be outsourced. There cannot be any appointment. There is a case, my lord, where, my lord, in contravention of this office memorandum, my lord, the petitioner has been engaged.
The engagement was by your concurrence.
No, it was by our concurrence, my lord, but precisely that I have had a talk with the department.
No, it's okay. Technically, you may be on a correct footing, but it's a post of a sweeper. And government is that till now he is discharging his duties. Can you have it done like this?
But,
If there was a ban, why did you concur with this appointment? Had it been some other post of requiring other higher qualification or post in the office,
My lord,
is the post of a sweeper
my lord,
discharging his duties.
yes, my lord, sir.
If you want, you can discharge him from his service, but to pay his salaries for the period which he have worked, have you communicated with the presiding officer?
My lord,
What is your future? What is your next course of action? If you think that he was inducted without following the due process, then put him out of this job.
my lord,
duly.
that is for the, my lord, the district and session, the
But can you prevent him paying of his salary?
No, my lord, Lordship will kindly consider one aspect of the matter. My lord, his engagement was not, my lord, brought within the roles of the government, my lord, by due process of law. So finance
You
department,
have taken as a defense the office memorandum, isn't it?
my lord.
But if see the process preceding his appointment, what did you concur?
My lord, the concurrence was with only regard to the, my lord, post, not in person, my lord. Post of sweeper, yes, of course it is there, my lord, that the page number.
And if it is outsourced,
My lord,
why do you concur? Your stand has to be consistent.
it may make some observation, my lord.
It
Lordship will-
cannot act as a precedent, but you cannot leave a sweeper with, cannot treat him like this.
Because of this office memorandum, my lord, that is the difficulty. Lordship, no,
Office memorandum, you haven't taken action. This matter is pending since 2021. Write immediately to district judge, remove him from the role because this is not permissible.
no, that is.
Until such time, you pay.
So that is, my lord, that will be within the domain of the.
You can at least have a communication.
Yes,
And after all, the amount would go from the government.
no, government, my lord, that's true.
That we had.
There will be head of account, my lord, but that head of account, my lord, if the, my lord, induction into the service is by due process of law, but then, my lord, SIU department, my lord, will swing into action, my lord, and then all.
What did you do at the time of appointment?
My
You
lord,
allowed the appointment.
appointment precisely, my lord, there was no proposal, my lord, moved to the finance department so far as the petitioner is concerned. Therefore, my lord, I'm.
How was the concurrence given that you can appoint? If the entire system was to be given, was to be outsourced,
My lord,
in in view of a decision of 2012,
yes,
he came into the picture much later.
yes. Now, this communication, my
I have
lord,
to resolve this.
now, my lord, so.
A person in the grade of sweeper discharging his duties, utilizing his service, no payment. This is wholly unfair.
No, my lord, so far as, my lord, the order passed by the judicial department for permanent retention of the post is concerned.
As on that, is there any outsourcing in the court?
My lord, here itself, my lord, it is outsourced.
No, in that court, Chirang court.
But that, my lord, the my lord, concerned department
Yes,
cannot be,
madam.
my lord.
Who is performing now the duties of a sweeper? Has it been outsourced? You should have the basic instructions, madam. Don't leave everything to your senior. You're not supposed to know the facts. What are you taking from 2021? Person is not getting his salary as sweeper. and you say need the instructions. Can you survive for a month without any money?
But the appointment letter.
You're dealing with a sweeper. You need to be extra careful and alert. He is claiming to have discharging his duties, not getting his salary. How does he survive? We are asking that whether you have also taken the records of outsourcing in the meantime. That is the first question which will come to you. Is he the one only who is discharging the job of sweeper, or have you in the meantime outsourced this aid work? And Mr. Borpujari, whether you pay by outsourcing or directly, ultimately the amount has to be borne by you.
No, my lord, it has to be borne by the, my lord, concerned administrative department. It is not to be borne only, my lord, if the.
Who is for the administrative department? Yes, judicial department.
Here, my lord, one aspect of that, kindly, my lord. Here, the materials on record nowhere suggest that, my lord, the concurrence of finance department was taken. It was all along, my lord, taken.
Borpujari will not be interested with your departmental dispute.
No, my
That
lord, if-
finance has not concurred, the judicial department is to be take the responsibility. Ultimately, who is suffering?
no, that is.
Can you run a court without a sweeper?
No, my lord, we are bound by this.
Whether it's outsourced or initial process may not be in feed by the due process, but it's a matter of fact that he's serving
Then, my lord.
and
they are-
the district judge says that he's
Yes.
doing his duties.
So that
Can
is
you
true.
run a court without a sweeper? You cannot.
So therefore, my
Now,
lord.
can you
since it is-
take a stand that we are not going to pay you?
No, my lord, we will.
Pay
be
him,
giving
let
the
him go.
record and- no, you will kindly appreciate, my lord.
Let
we
us
will-
see his appointment letter.
Yes.
We will not accept this kind of stand in this instant, this particular fact. You take this stand in other cases, not in a case of sweeper. Where is your appointment, Mr. Kotoki?
36 page, my lord. Sorry. Well,
Sir, his appointment order goes to show, my lord, that no concurrence of the department was taken, finance department.
Against the post sanctioned by government letter dated 31/3/2007.
Yes.
What has happened to this post?
No, so therefore, my lord, the judicial department perhaps will have to file an affidavit here, my lord. How they have sanctioned the post.
We will not allow this matter to be treated like a ping pong. You send it to the judicial will send it to the finance, and ultimately who is suffering?
No,
This
that-
ping pong game has to end
My lord,
somewhere.
My submission will be, my lord, kindly, my lord, my submission will be, if a person is, my lord, engaged, because the provisions of this, my lord, office memorandum, my lord, we cannot step in, my lord. That is the difficulty.
Then how do you resolve this?
My lord, it is to be resolved by them, my lord.
Who?
My lord, the judicial department and my lord, the concerned office of the district judge, because they have not taken concurrence, my lord.
Yes, judicial department.
Not a single document piece of paper is available on.
Yes,
my
Mr.
lord.
Bhattacharya. I'm paying for today, my lord. That will not help. Today you are there, tomorrow somebody else will be there.
No, my lord, I will inform, I'll take.
No, presently the work of sweeper being outsourced presently in your court, in the court which you are concerned. You say that you have certified that the petitioner is discharging his duties. They have taken a stand that since 2012, the work of sweeper has been outsourced. Now, as on date, this is which court? Chirang Court.
Chirang Court was established in 2015 and there is
Understood. Now, after 2000, as on date, is this post or work being outsourced or is it still done through one person?
in our affidavit that point of time that he is still continuing. That was the.
That we have understood.
My lord.
Are there any other persons discharging the duties of sweeper whose work has been outsourced pursuant to 2012?
My lord, then.
Immediately come up with instruction, Mr. Mohan.
My lord.
We'd like to resolve this issue. We cannot, the sweeper cannot go without his salary.
No, my lord. What I am
And
asking,
whatever
my lord, that
dispute is there, you have to
advertisement-
resolve
when
in between.
advertisement was issued, my lord.
So, Bharpati,
the
advise your
government was there.
judicial department. Yes.
Because judicial department.
All the.
Yes, Monday we'll have this matter. Monday. Monday, ask the senior government advocate to be here. Mr. Nath, Mr. Bhattacharya.
Because he
Come.
was appointed as a
Please
permanent
ask him
sanction.
to come prepared with the instructions.
My lord, he was appointed as a permanent sanction post, my lord. At the time of creation of the court, my lord, there are three posts were sanctioned, my lord, by the government, my lord.
No, we have seen in the appointment letter, you have referred to an order of 2007 by
Madam.
which this post was sanctioned.
Yes,
Now, finance has come up with a plea that since 2012, there's a policy decision to give all works of sweeper job to, it should be outsourced.
Fine.
That is okay, but after the decision, the appointment has been made.
my lord.
Now the appointment have been made. The
No, my lord,
salaries
but
are
that
required to be paid.
appointment, my lord, that appointment, your lordship kindly see that appointment, there is a government, my lord, giving clearance to that. So that's why, my lord, and the district made an interview.
So, Bharpati, two departments cannot talk in a different way.
Different-
Ultimately, you are one. One wing saying something else, the other
No,
one.
sir,
This is not accepted.
no, so therefore, let the judicial department file an.
Your interdepartmental disputes, you are not here to resolve the
Because it
dispute.
is, my lord, your lordship kindly
Lordship
see
will,
one point.
lordship will kindly.
Monday you come prepared. Monday we are going to pass orders. And if you take such
It
a
was
stand,
sanctioned in
you'll have to face
2015 by the
consequences.
Judicial department.
You have to face heavy
Three
consequences.
posts were sanctioned, my lord.
He's speaking by two voices of the two departments. This is not going to be accepted. We have this. This is on record. We have seen.
My lord.
Heard. We. This is item number. DK Kotoki, Learned Counsel for the petitioner. Whereas the TJ Mahalan Senior Counsel is present for the respondables 3 and 4.
My lord. 3 and 4.
We are Bharpati, Learned Senior Counsel Finance has however submitted that from the year 2012, there is a policy decision to outsource the work relating to sweepers in the court,
Sweeper in any department.
any department, sweepers
department.
in all departments
Yes, my lord.
also. He accordingly submits that the appointment of the petitioner as sweeper in the court of the district of Chirang was not in accordance with law. The dispute is with regard to the dispute is with regard to not getting of non-release of salaries to the petitioner since August 2016. The documents put on record, however, suggest that in spite of such policy decisions, the appointment was duly made after a selection and in a sanctioned post. This court is of the opinion that when such appointment is preceded by a due process, and that too in a sanctioned post, one wing of the government, namely the finance department, cannot take an inconsistent stand. Para, list this case on 21st 8. However, the KK Bhattacharya, Learned State Counsel appearing today, has submitted that he does not have proper instructions from the judicial department. Let the matter be listed on 21/8/2023 for final consideration. On which date, comma, this court expects that the judicial department would be duly represented.
Lordship, one submission, but if my lord may be pleased to direct the judicial department to place on record any conference by the finance department. or-
Without the council will not be to pass that on Monday.
Because the pleadings are silent, materials are silent.
Monday.
My lord.
Mr. Bhattacharya asked him to come up with instruction.
Yes. Problem.
My lord, in this case, I am not the main counsel, my lord, if my lord can accommodate
50,
53, my lord.
53.
Unfortunately, both the councils, my lord, one,
You want some time?
yes, but a short accommodation if my lord can.
You're making a request on behalf of your colleague or what? Or
Yes,
you are
yes,
appearing?
yes, yes, my lord, I'm the.
They are out of station.
Yes, my lord. One council is, my lord, he's suffering from fever and another
doesn't
is from.
Doesn't matter. Okay.
Lordship, can you allow to call my senior lordship? There is an urgency lordship. He's in there.
No, councils are not there. We will not take up this matter.
Earlier, the lordship had the matter lordship. It can not matter lordship on
Earlier
execution.
it was, my lord, listed.
Monday
on
we'll have
orders.
it.
Lordship.
Monday. Day after tomorrow is a holiday, on Monday we'll have. it. Okay. A prayer for adjournment has been made on behalf of the petitioner as the learned counsel is said to be suffering from some ailment. However, urgency has been expressed on behalf of respondent. Considering the same,
Can it
please directed to be this case on
22, my lord, 20. Hearing date.
22nd,
Hearing.
22nd, next Tuesday,
Hearing date.
28.
Much better.
Can it be disposed of?
Sorry, my lord.
Can it be disposed of?
Yes, yes. my lord.
Lordship,
Yes, my lord.
Yes.
For this matter, I had mentioned in the morning as well. What had happened is that I followed up as per law. But unfortunately, although I must say, if only I want that my,
How- 3S Bonik.
on that count, if I may pray for time, that accommodation, these people,
We'll
I understand. Once everything,
record this. Third 3S Bonik Learned Counsel for the appellant. Full stop. None appears for the respondent. However, none appears for the respondent. This appeal is of the year 2009, which was admitted on 8/6/2009. Full stop. The suit is of the year 1993, being title suit number 103 of 1993. Full stop.
it goes far prior, 1 of 84.
Pre-Bonik, the learned counsel for the appellant, however, submit that on being informed that the appellant number 4 had died on 8/1/2015,
18-1.
18/1/2015, comma, a registered letter was issued to his client for taking necessary steps for filing appropriate application. But only one appellant has died. Rest are there.
Rest are there, but the rights would be affected.
No,
The
for
rights-
him it will be abated.
It
Rest-
would be abated only for him,
Okay.
but the rights would be affected, and that would be their argument. Had I been on the other side, I would have argued that only.
No, but abatement we cannot do for others.
No, not for others. Only so far as 4 is concerned, it's sense abated.
No, only 4 years.
I wanted to take some time in case they turn up.
Yeah, well, we thought that we will be able to dispose of the appeal. He had to issue a registered letter. So last time. However, there is no response. Accordingly, the appeal stands abated. So far as the respondent, so far as the
Appellant number 4,
appellant number 4 is concerned.
Kokon Chandra Mehdi.
Full stop. That this, that the appeal be listed for
Hearing.
hearing in the second week of September.
That-
You have
Will it be
a
part of
copy,
the- I have a copy. Will it be part of the record?
a copy of the letter dated 23/5/2023 issued by the learned council
Along with the acknowledgement due.
along with the copies of the AD card are kept on record.
Obliged, Lordship.
Yes, madam, what is this?
May I please your lordship? As per office report dated 27/6, the notice has been duly served to respondent number 8. And it was received on his behalf by his father. With this, service to all the respondents has been completed and we request the court to condone the delay of 23 days.
How many days?
23 days.
Yes.
I am for one. I am for the for number 6. Fine.
Yes, madam, what is your name?
M. Chetia.
Here for Mr. Idris Sekia,
Yes.
for MSM Sekia, council appearing on instruction of the Idris Sekia, Learned counsel for the applicant, who by means of this application filed under section 5 of the Limitation Act has paid for continuation of delay of 23 days in preferring the connected appeal against judgment and award dated 3/12/2014 of the learned MACT Kamrup in MSC case number 546 of 2010. Full stop, para. The learned counsel has referred to the office note dated 27/6/2023 and has submitted that service upon the response number 8 may be held to be complete. Full stop, para. The other respondents are represented by MS. Yes, madam. Here for whom?
Insurance 6, respond number 6, L Sharma.
No, no, where are you? R6
1 to 4, 1, 2, 3 and 4.
and
A
what is your
Burwa.
name? A Barua.
Yes.
Sri A Barua learned conflict is present for the respondent number 1 to 4 and MS L Sharma for respondent number 6. What about the other respondents, madam? 5, 7, served or not? Five and 7? No question. Okay, good. Okay. 5 and 7, madam. Who is 7?
5 is the owner and driver.
7?
7 is
Two
also
vehicle-
owner. There are 2 vehicles, madam.
5 and 7 not served, madam.
Owner is party item.
Because 7 has been served. And the other one, 5? If you can discuss.
Has been served.
5? Eight. 5 served where? 5 you have not taken steps. You would have controlled the detail. 5 notice has come back in 2019 with insufficient address. No fresh step. Five, we have to take steps, madam.
Right.
I think it's a step. The AD earlier office note dated 28, 2015. Shows reflect that AD card in respect of respondent number 7 has been received back, and therefore the state respondent is served. However, the respondent number 5 is yet to be served as served, and in this regard, comma, fresh steps were directed to be taken earlier. Full stop, para. MSTT Learned Council, however, submit that due to inadvertence, comma, fresh steps could not be taken upon respondent number 5, and accordingly, please for some time to take fresh steps. Full stop, para. Let fresh steps upon respondent number 5 be taken immediately, as this appeal is of the year 2015. Steps be taken by the state post AD. List after 4 weeks, along with 4 in the 5 weeks, 5 weeks, along with report on fresh service upon the respondent number 5. Okay, if the report is that it's not being served, then we can presume service. If it doesn't return,
May it please your lordship. This IA is for delay of 147 days. And
step taken.
I have no objection of that.
Others,
Respondent number 1, 2, and 3, lordship for claimant. The other is the
Regarding-
owner of the vehicle.
others,
my lord, only respondent number 4. And as per office note dated 29/12/2017, AD card is received back with signed by someone, Sophia Masoom, my lord.
17,
My lord,
service is complete or not? Third,
The 2016 IA. The mayor lordship, IA may be lordship allow condoning the delay. And
let us see whether notices have been served or not. Here for, not for
claimant number 1, 2, and 3.
respondent number 1, 2, and 3.
The respondent number 1, 2.
As step complete. AD card, system number 4 has received back 4, 1, 2, and 3 has returned 1, 2, 3, 4, 4. How many respondents are there?
4, my lord,
4.
4.
Okay, then we complete. Card MS Mutahari,
My lord,
Learned Council for the applicant who has taken 5 against judgment and order. Also, Sri M. Khan, Learned Council, who has entered appear, who is present for the respondent numbers 1, 2, and 3. Full stop. office note dated 29/12/2017 reflect that respondent number 4 has also been served. Mr. Para. MS Musahar is the learned counsel by explaining the to explain the delay of
147, my lord.
147 days has referred to the amendments made in paragraph 5 of the application, as per which, comma, it has been submitted that the delay had occasion because of some office formality, and there was no negligence or latches. Para. Three. The learned counsel for the respondent was 1, 2, and 3. Fairly submit that he would not object to the continuation of delay. The para. In view of the above, comma, and taking into consideration the settled principle governing the consideration of a delay continuation petition, which requires a justice-oriented and pragmatic approach, comma, the delay of 147 days is controlled. I accordingly stands allowed in the main appeal, right? In view of this principle of today, whereby delay is controlled, office is directed to register this appeal and list for admission immediately.
My name may be reflected in the.
Let the name of the F be reflected because as learned counsel for the respondent numbers 1, 2, and
Obliged.
In this case, the notices were returned back unserved. As
you
regard,
file your formal power or not?
but I have,
File your formal power. You made it clear last occasion. It's not
yes,
a,
my lord,
they are to be learned counsel appearing on instruction. Submit that some time may be given. That submits that too, he has been instructed to appear. Comma, formal power, formal wakalat has not been filed. Sarah, this court is of the opinion that taking into nature the taking into account the nature of this appeal and the parties involved, comma, a formal wakalat is necessary. List after 2 weeks.
can you take it next week, my lord? We will be filing by tomorrow.
And let's see, list next week. By which time such wakalat may be filed. Wakalat may be filed. File in the other cases also.
Yes,
Doesn't
my
look
lord,
good.
my lord, I have asked,
Doesn't look good.
by tomorrow we'll be filing that.
Yes, the other.
My lord, in terms of office number 19/7, my lord, respondent 1, 2, and 3, they not served, my lord.
I'm appearing for.
There is a
respondent
note
one,
that
insurance-
respondent 2,
Insurance company.
Number 1,
Yes.
2, and 3.
there is a note, my lord, the respondent 2 is left the address, my lord. My lord, I found that the same address, my lord, only the house is different, my lord. I'll take fresh steps, my lord.
And 3.
3, my lord, service is awaited. My lord.
3, when did you take step?
My lord, that long back, I'll take fresh steps on R2 and R3.
3 is from which place?
It is
It
from,
was taken in 2020. I think you take first
Well-
step. Third CP has a recollect counsel for the appellant, whereas MSL Sharma Learned Counsel is present for the respondent number one insurance company.
Yes.
Office note reflect that respondent numbers 2 and 3 are yet to be served. Full stop. Sri Hazarika, the Learned Counsel, praised and is granted a week's time to take fresh step for service of notice upon the respondent numbers
2 and
2 and 3 by registered postpaid.
Matter will be placed before the Lazima court.
No, really, I have list of the 6 weeks along with service report.
published.
If it doesn't return, then it's sent it to Lazima court
Well,
for.
Public.
Next.
May I please, your lordships? I am extremely sorry, my lord. I could not take steps, my lord. Just tomorrow I'll. Unfortunately.
Office note dated 14/9/2022. Not office note, order dated 14/9/2022. Reflect that fresh step upon respondent number 2 has not been taken. Full stop. 3 submit Learned Counsel for the applicant. However, submit that due to inadvertence, there has been a default. Full stop. Sarah, Learned Counsel is accordingly granted a week's time to take fresh step upon for service of notice upon the respondent number 2 by registered post PTT as well as by usual process as directed earlier by the order dated 3/6/2020.
Much
Both
obliged.
ways.
Obliged.
Yeah, please, your lordship may be pleased to take up IA civil number 722. Is an IA for setting aside abatement. In fact, there was a delay. The delay has already been conducted on last occasion.
Yes.
Yes.
What do you do? What do you want?
Yes.
What do you say?
Your lordship, today, this 722 is for substitution, your lordship. Another day, your lordship, the condonation of delay was condoned, your lordship.
Yes, the abatement was also there.
Abatement was done.
Abatement has been set aside or not?
Only the section 5 application has been disposed of.
This is under what?
This is
22
under
rule
order.
9.
Rule 9.
Yes, what are the reasons? What do you say, madam? On this setting aside. It was abated in respect of whom?
Respondent number 3.
R3.
R3.
What is the name?
Lakshmi Rani Fund.
Lakshmi Rani Dhar.
Lakshmi Rani.
Yes, you're for whom? The government.
Yes, Deputy Commissioner, your lordship. Respondent number 5.
And madam,
1A
1A to 1F. Was notice issued in this petition? No.
Yes, ma'am.
Notice has been issued.
Notice was issued in the section 5 petition.
No. You have to issue notice here. Without giving a chance, it will not. Ultimately, abatement is there. G. Bharadwaj.
My
Heard to G. Bharadwaj learned counsel for the applicant, whereas MSK Phukan learned state counsel is present for the as per number 5 and MS M. Burman for
1A to 1F.
for as per numbers 1A to 1F. Full stop. This said application is filed under order 22 rule 9
My
for setting aside abatement in respect of response number 3. SMT Lakshmi Devi Dhar,
Lakshmi Rani.
Lakshmi Rani Dhar. Full stop. The learned counsel submits that the delay in filing this petition has been condoned by the court. So that notice be issued returnable by 6 weeks. RS of 2006.
6
My
months.
God,
Lordship may allow me to take steps by Dusty also.
you can.
Yes.
But there are many respondents.
5 respondents.
Not 5. A, B, C, D. 5 is the. After every respondent, they have been substituted. Returnable. Let's have to take it by usual process. Full stop. The learned counsel prays for taking of steps. Prays for liberty to serve justice. Full stop. Let serve justice additionally. Full stop. Liberty is granted. Full stop. Let steps be accordingly taken by justice service, which is required to be routed through the registry of this court. Let the next date be fixed on 18/9. Full stop. Let the notice accompanying the justice reflect the next date fixed in this case. Full stop. On or before the applicant is however required to file appropriate affidavit in support of such justice prior to the next date.
It's office note dated 2/8/23, says that this steps I have taken, but it is answer notice returned in respect of 2, 3. And 1 and 2 is not returned, Lordship. So I will take another steps in the local address of the insurance company.
Yes, sir.
2/8/23.
Unserved notice. What do you propose now?
I'll take fresh steps again in the local address of the
Upon?
insurance company.
As per number?
All, Lordship.
In view of the office note dated 2/8/2023, 3 A.R. Agarwala, learned counsel for the applicant, prays for another opportunity to take another opportunity to serve the respondent numbers 1, 2, and 3. Put the para- That accordingly, let fresh steps be taken upon the respondent by registered post with AD. Some steps may be taken in any other alternative. Please, steps be taken. Such steps be taken within a period of a week. List after 6 weeks along with service report.
May it please your lordship. Lordship, the IA is for delay of 149 days. And in regards to respondent number 2, the notice has been received and signed by the respondent's wife.
Lordship, I am appearing on behalf of opposite party respondent number 1, there's a claimant. So far the delay is concerned, your lordship, I have no
Who was
objection.
for, you are for 1 and then 2 and 3?
Your lordship, office note dated 9/3/23, notice issued upon respondent number 1 and 3 by usual process. Respondent number
Signed
1
by
and
the
3 duly
wife.
served.
So two has been served. 1, your Mandoli is there, and 3,
1 and 3 is served.
3 who's there?
Office note dated
Will-
9/3/23.
No, sir, no, no, no. Okay. Your name,
K. Upamanyu,
you're on record or not?
on behalf of Mr. S. Dattu.
Sri K. Upamanyu, learned counsel appearing on instruction of Sri S. Datta, learned counsel for the applicant by referring to the office note dated 9/3/2023 and 2/8/2023 has submitted that service upon the respondent is complete. Prepare. Sri D. Monta, learned counsel is present for the respondent number 1. You file objection.
No, no, your lord. I have no objection at the
How
delay.
much is the delay?
149 days.
Sri, para. Sri Upamanyu, the learned counsel submits that the delay of 149 days had occasion due to certain office formality as the award has been passed at Lakhimpur and the opinion of the regional officer at Guwahati had to be taken. And in this regard, he has referred to the award made in paragraph 6 of the petition. Full stop. Para. After hearing the learned counsel for the Sri Wanton, learned counsel for the respondent number 1, however, submit, however, fairly submit that he would not have serious objection to the prayer for condonation of delay and condonation of delay. Considering the above and the settled law, I recommend it. I allowed for hearing main appeal to be.
Your lordship, one line may be added while listing the appeal
Your
for
name.
admission. My name may be
Highly
highly obliged.
My lord, I am for opposite party respondent number 2A to 2E, my lord.
Who's for the petitioner? Applicant, MP staff.
My lord, respondent number 1 has died.
Respondent 1 has passed away.
Yes, my lord.
Your name?
M. Hussain, my lord.
M. Hussain.
I am appearing on behalf of Mr. N. Hoffman.
N. Hawk.
In
None appears for the applicant on call. Whereas Sri M. Hussain, learned counsel, appearing on instruction of Sri N. Hawk for the respondent numbers 1 and 2, submit that the respondent number 1 has passed away in the meantime. However, in absence of learned counsel for the applicant, this matter cannot proceed, and therefore, in the interest of justice, it is adjourned with a direction to this again after a week.
Most of the.
May I please, my lord? My lord, may I kindly peruse the office note dated 10/5/22, my lord? My lord, service upon respondent number 1, 2, 3, 7, 13, 14, 16, 17, 24, 27, 28, 34, 39, 40, and 41 are complete, my lord. However, my lord, respondent number 23, service report has been returned due to insufficient address, and remaining are service awaited, my lord.
Here, Mr. Mehdi for
I am for 39.
only one respondent.
Yes, yes.
And other, Mr. Das,
I am for 34.
32,
34.
34.
I am for
Four.
2 TL folders.
And that's for 25 and 34.
I am only
34. Who is for 25? 24 and
My
34.
lord, 35 is service.
No, 25 and 34.
Uh,
25.
Mr. Saikya, my lord, GJ Saikya perhaps.
Yes. The BDAS,
Bidas, my lord.
current concept for the appellant by referring to the office note dated 15/3/2023 has submitted that while the LCR has been received, comma, these respondents have been served. 7, 13, 14, 16, 17, 27, and 28. Have you checked the file?
Yes, ma'am.
Served or not? Served. Service. Get a separate file. Yes. There is also an indication that service report has been received so far as respond numbers 7, 13, 14, 16, 17, 27, 28, 39, 40, 41, and 42 are concerned. However, comma, I got service report by user possibly. However, comma, neither ID card nor unserved notice has been received on behalf of respondents 5 to 48. Also, para 3. The learned conflict has entered appearance on behalf of respondent of 25, 29,
No, my lord, 39.
And-
my lord.
Huh?
That is wrongly,
39.
yes, 39.
25, 34, and 39.
Yes, ma'am.
And in fact, 3 A.R. Medhi and 3 UK Das, Learned Council are present in the court. 3 T.R. Gogoi, Learned State Council is present for respondents
2 TL folders.
2, 3, and so para. List of the list before the learned Lozima court to pass appropriate orders with regard to the service upon the respondent. So far as registered, so far as step where registered AD post is concerned.
My lord, the perhaps service upon respondent number 23 is in record, my lord, is unserved, my lord, due to insufficient address.
Or 23.
Yes, my lord.
Sir, I got it. Three, does the learned counsel for the appellant, however, submit that the service upon respondent number 3 has returned back due to insufficient address.
Yes, my lord.
The learned counsel for the appellant is accordingly granted a week time, 2 weeks time to take first step for the state respondent number 23 by registered post AD upon on the correct address.
Mobilize, my lord.
That's the close, ma'am. Except the yes, madam.
Please, your lordship.
Mhm.
Service upon respondent number 1 has been completed by substituted manner and affidavit is placed on records. So, and if your lordship is pleased, LCR may be sent.
What about the other respondents?
The other respondents, we have already sent the
There are 2 respondents, madam. How many respondents are there? Yes, your and Ghar and Dakar,
and the car.
third MS and Dakar learned conflict for the appellant who submit that the affidavit pursuant to the paper publication has been filed. Full stop. Peruse the same. Full stop. Service is deemed to be complete. Please, Sarah, please this appeal for hearing in its turn.
May I please? Look, this contempt petition has been filed for violation of order dated 3/11/2021. The relevant question is at page 40.
Four zero.
The second parameter.
It will- Why is it come before this court?
And Lord, earlier also the same issue was raised, Mindra, and the registry was directed to verify and.
No, we
place
don't
the-
mind taking up this matter, but this is a bench on matter. This contempt is of a criminal matter.
Yes, Mindra.
Why did you before
There is an office order.
office order?
Yes, sir.
Yes, which order?
I have forgotten the date. Office of a trust and here. Civil bench one, why? Civil bench one.
According to his view of the his personal orders is to ensure resident director to verify the matter and respond to appropriate. His contempt of partition not compliance on orders is criminal duty. According to view of the same as verified by the filing section and after verification, rectification matter has been placed for the appropriate bench number 1. You didn't honor me. Huh? No. Contempt. Particularly mentioned. What is the stage now? Yes.
My lord, in this case, actually, no contempt lies against the present respondent. Because the operative, if you lordship would peruse the operative portion of the order, which is
Page
my learned friend relied page
Page
40.
40.
40, what he had relied.
Sir, Rafiq, which
And
Page
which
40,
page?
page 40 meter,
40.
40.
in this, by this order, this honorable court, a coordinate bench of this honorable court directed to dispose of the said disputed issues between both the parties within a period of 3 months. What happened in this case, my lord? While filing this contempt petition, I have, appearing on behalf of the respondent, have filed my affidavit in opposition by responding all the contention raised by the petitioner before this honorable court with regard to the issue of contempt. My lord, in paragraph 13, in my affidavit in opposition, lordship will find the entire case along with the supported annexures what we
Yes.
have filed. Page number 47 of the affidavit in opposition.
Yes.
And paragraph 13 of the affidavit in opposition.
This page?
Paragraph 40, page 47,
Yes, yes.
paragraph 13. Page 46 on.
Yes, you are not appearing.
Let your lordship kindly see, I have submitted the copy. Thereafter, no notice has been issued. And now, suppose both the party has not appeared, my lord. He could have dismissed the petition, my lord. That was not done and
No,
kept
he
the
has
matter
given for
pending.
further hearing. There is an
Further
order of
hearing.
this
I
court.
cannot dismiss because this honorable court
Court
particularly
Court has
directed.
directed, yes,
No, no.
court has directed to complete the proceeding
Yes.
within a period of 3 months.
Yes.
Thereafter, I have submitted the copy of the order. And thereafter, my lord, nothing has been done.
But the lordship may kindly. Annexure A,
Both parties have sent like that.
three
Why is it
consecutive
appear? You
days.
have not appeared.
Three
I have
consecutive
not
days.
received any notice from the court, my lord,
No
because
notice
the
is
matter
required
was
where
kept
the matter
pending.
is within the knowledge of both the parties.
I have submitted the petition. Is a 145 proceeding, my lord, kept pending till since 2018, my lord. Whereas the title suit has also been completed, my lord. And in the 145 proceeding, there is an order.
If you say that notice have not been given and there were dates one after the other,
Yes.
when did you go before to the office making an inquiry? After filing of this order, copy of the order of this court,
Yes, my lord.
when did you go? Where is your statement that you have visited the office?
That is statement I have not made. my lord.
Then how do you this? Contempt is something which is deliberate and willful. The respondent has fixed the date, 2 days. And what happened on 24 to 2022? Thereafter? What has happened to the matter now?
This is still pending,
145.
145, since 2000.
And in the meantime, my lord, I have been transferred in the month of January 2010 to other department,
When?
January 23.
In this case, what happened, my lord, there was a title suit also that has been.
We close this. We grant you liberty to serve a copy of this last order to the
Yes.
present incumbent.
Yes.
And we also fix the date
Yes, sir.
because the other side is not before us
Yes, my lord.
in the main process. He'll issue a notice
Mm.
and complete it. Third, three, I Rafiq. This item. learned counsel for the petitioner, whereas the A Paul is present for the respondent. Full stop. In this petition filed under section 12 of the Contempt of Court Act 1971, read with Article 215 of the Constitution of India, comma, the petitioner has alleged willful and deliberate violation of an order dated 3/11/2021 passed by this court in criminal petition number 100 of 2021. Full stop. It is the case of the petitioner that pertaining to a dispute with another party, comma, apart from a title suit being title suit number 12 of 2018 in the court of the learned Munsif, Ramia, the other party had instituted a proceeding under section 145 of the CRP. The this court in the where is that order?
Annex 7, page 38.
This court in the criminal petition number 100 of 2021 instituted by the petitioner against the 145 proceedings had, however, passed an order dated 3/11/2021, whereby a direction was issued to the learned executive magistrate to decide the petition by examining all witnesses from both the sides and dispose of the same within a period of 3 months from the date of production of the certified copy of the order. Full stop. Para. Rafiq, the learned counsel, has submitted that in spite of furnishing certified copy of this order, comma, the state direction has not been complied with, and therefore it is submitted that the present is a fit case for initiating contempt proceedings. Full stop. Para. Per contrast, comma, the A. Paul, learned counsel appearing for the respondent, has submitted that the allegations made against the respondent are not correct. Full stop. By referring to the affidavit in opposition filed on 20/12/2022, comma, the learned counsel has submitted that immediately on being apprised of the order of this court, comma, the proceeding was taken up with the right earnest and dates were fixed, and in none of the days, comma, the parties were present. Full stop.
Absent.
None of the days the parties were present.
Sorry.
If you don't understand, keep quiet. The order sheet has also been annexed as Annexure A to the state affidavit in opposition, from which it reflects that the proceeding was taken up on 26/11/2021 30/12/2021 and 27/1/2021, in which the parties were absent. He accordingly submits that it cannot be said that the present is a case of willful and deliberate disobedience, and rather all steps were taken by his client for compliance of the direction of the court. It is also submitted that as on date, his client is not holding the state post of executive magistrate, Rongia,
Yes.
and has been transferred to
Under Secretary, Ministry of Health and Family Welfare Department.
uh, to another department. Another department in the government of Assam.
His headquarters is Tezpur now.
Another department in the government of Assam and is posted at Tezpur. Para. Sri Rafiq, the learned counsel for the petitioner, however, submits that at no point of time, notices were issued to his client, and therefore they could not appear. An application alleging contempt is required to be examined considered by examining the conduct of the respondent against whom contempt has been alleged. It is a settled law that such disobedience, non-compliance, has to be willful and deliberate. Suppose, in the instant case, the record and the the pleading supported by the record would reflect that steps were duly taken for compliance of the order of this court, and the proceeding under section 145 of the CRP was tried to be continued, in which the parties were absent, and therefore the matter was deferred. This court has also taken note of the fact that the respondent is not holding the same post at the moment. This court is of the prima facie view that during the tenure of the respondent as the executive magistrate Rangia, few steps were taken for compliance of the order, compliance of the direction of this court, and therefore the allegation of contempt does not appear to be substantiated. According, the present petition stands closed. Present proceeding stands closed. However, in the interest of justice, however, keeping in view that a new incumbent has joined the post of the executive magistrate Rongia, for meeting the interest of justice, the petitioner is at liberty to approach the present executive magistrate Rongia with a copy of the order, copy of the initial order, along with a copy of today's order, with a request to issue to restart the proceeding and brings the same to a logical conclusion. Full stop. It is, however, made clear that the learned Executive Minister Dongya is required to issue notice to the parties, notifying the next date, so as to enable the parties to appear and face their respective cases. In terms of in terms of the order date, what is an order? So, order dated 10, was it
311.
3/11/2020?
Obliged.
Contempt petition is approved. Thank you. sir. Yes, and we have a meeting of rise. Any matter where interim order is today?
My lord, one item on 48, my lord, so many times it was listed for hearing, but it is not placed. If it is fixed on 23rd of.
He'll give a date. Court master will give. Any matter where interim order is
In item number 50, my lord.
interim order is
Yes.
50. Positive. 2 weeks. Interim order.
No,
my
my
lord,
lord, there is no date, my lord.
Huh?
In the interim order, there is no date. I have filed this objection petition for listing today, my lord.
The proceeding in the
Sir,
lower court is stayed, my lord.
So it is up,
That will be
it's not
extended.
limited by any date,
Yes.
so why are you extending?
Hmm.
No need to-
Until further order is there.
I have a date.
Yes, my lord.
After 2 weeks.